How are you? Thank you, thank you. All right, I'm starting recording this. Okay, I'm leaving it there. So I need to-
En el sueldo, sí, ¿cómo es feito por delicioso? El caso, siempre es una barra, es una popular. Creo que sí, pero dos, pero una chela. Me divertí, me divertí muchísimo. Competencia, regulación, práctica. Pero quiero poner una regulación. Buenos días. Bienvenidas, bienvenidos. El mejor trabajo de la red nacional. Lo que después es político. Sí, me da. No hay que ser, no hay que ser tan rápido. Ay, qué bueno.
En una sesión con el popular, yo soy fan de ustedes, siempre y hacen caso a
Esto quiere decir que nosotros muy complicado, pero estamos bien. Yo digo que la disponibilidad de los tiene una guerra que bastante importante. Parece que se olvidó un tiempo de llegó a este país como oportunidad. Y hoy es de los más importantes sectores de la en la que estoy. Primero que todo,
tiene competencias muy fuertes. No pasa.
Perfecto, sí. Ya estamos. Va llegando la gente y ya estamos aquí grabando. Y ya nada más hay que venderlo.
Hasta ahorita porque ya una hora y sí la consideras aquí. Yo ya todo hasta aquí. Ya lo logré. Pero mi hermana
Hello, we'd like to invite you to all take a seat. We're going to go ahead and get started. Okay. All right, thank you for joining us for the 2025 Mexican Legal Perspective Symposium. I would like to introduce myself as the new Assistant Director for the Mission Foods Texas-Mexico Center and wish you all a warm welcome in addition to on behalf of our sponsors. And can you hear me all? No.
Yeah, hear you.
All right, should I round two? Okay. Yes. All right. Thank you for joining us for the 2025 Mexican Legal Perspective Symposium. I would like to introduce myself as the new Assistant Director for the Mission Foods Texas-Mexico Center at SMU. I'm thrilled to be here and wish you all a warm welcome in addition to and behalf of our sponsors and partners. So we have Tecnológico de Monterrey, el SMU Rowling Center for Business Law and Leadership, the Dallas Bar Association, and the International Law Section. Thank you very much for your contributions and your support, without which we could not be here today. And to get started, we are going to hear some introductory remarks for individuals. I will be introducing them very briefly, but I would invite you all to read through their extensive biographies here in the program, where you can learn about their successes, their accolades, and their contributions. And to start out, we will first be hearing from Pablo Mijangos, who is, hold one up here. He is our Edmund. He has the title of Edmund J. and Luis W. Kahn Chair in History for the SMU History Department. We're very excited to hear from you, and if Pablo, you could join us here.
Thank you, Corny. Good morning, everyone. Thanks for being here with us today. Well, we have a long day ahead of us, so I will try to explain briefly why this symposium is particularly relevant for SMU and the legal community in Texas. Over the past few months, many analysts from around the world have wondered whether the ongoing changes in US foreign and economic policy amount to the end of an era in international relations and world trade. The simultaneous imposition of tariffs on many countries, including some of the oldest and most important allies of the US, has filled international markets with uncertainty and negative expectations about the possible consequences and ramifications of a worldwide trade war. What this conversation seems to be assuming, however, is that the US is the main source of the ongoing changes and that the world is just waiting to know what will happen here in order to adapt itself to the new environment. And this assumption cannot be more misleading, for the world has been changing for some time now, to a degree that American media and universities have not fully realized. This is particularly true in the case of the US southern neighbor and #1 trade partner, Mexico. As most of you know, on June 2nd, 2024, that is almost 1 year ago, the Mexican electorate gave an overwhelming majority to Morena's presidential candidate, Claudia Sheinbaum, and her coalition's candidates for the houses of Congress. Morena also became the ruling party in 24 of the 32 states that compose the Mexican Republic, which transformed this party into an hegemonic political force with the necessary power to transform the national constitution radically. The guideline for such changes was defined by former President Andrés Manuel López Obrador in February 2024 in the so-called Plan C, a set of initiatives for constitutional reform designed to create what he properly called a new regime. Let me emphasize this point. What has happened recently in Mexico is not merely a political change embodied in the rise of a powerful leader and a new party in control of the entire political system. It is a constitutional transformation, a radical change in the rules of the game and the structure of the Mexican state. What are the key reforms I'm talking about? There are some reforms that deal with the public security apparatus and the role of the military. The reforms, for instance, gave Congress the power to authorize the involvement of the armed forces in areas of government traditionally managed by civilian institutions, such as infrastructure projects, customs, and even public health responses. Morena also increased the number of crimes that warrant mandatory pretrial imprisonment, which severely undermines the constitutional principle that a person is innocent until proven guilty, in a country with an already overcrowded and dangerous prison system. The reforms also targeted independent regulatory agencies, such as the Federal Economic Competition Commission, COFECE, and the Federal Telecommunications Institute, the IFT, which will now be integrated into federal ministries. In the same vein, Morena dissolved the National Institute for Transparency, Access to Information and Protection of Personal Data, INAI, transferring its responsibilities to federal executive agencies. This move undermines transparency and accountability and seriously compromises the impartial oversight previously provided by the Independent Institute. In the crucial energy industry, Mexico's recent reforms also mark a significant shift toward state dominance in the sector. The constitutional amendments reclassified the Federal Electricity Commission, CFE, and Petróleos Mexicanos, Pemex, as public entities, reversing their previous status as productive state companies established during the 2013 energy reforms. This change mandates that CFE generate at least 54% of the nation's electricity, ensuring a majority state-controlled energy supply. In tandem with what I mentioned before, the reform also dissolved the independent regulatory bodies, namely the Energy Regulatory Commission and the National Hydrocarbons Commission, transferring their functions to a newly established National Energy Commission within the Ministry of Energy. Among the different changes, judicial reform is probably the one with the most significant consequences in the long run. The reform removes all justices from the bench, from justices of the peace to the Supreme Court justices, and mandates that all judges in Mexico be elected by popular vote from candidate lists proposed by political bodies, essentially Congress and the President, thus destroying the previous merit-based appointment system. To ensure that the new judiciary will follow public interest as defined by the government, the reform also restructured judicial oversight bodies and introduced a judicial disciplinary tribunal, Tribunal de Disciplina, composed of 5 members elected by popular vote. Additionally, the reform eliminates the federal court's ability to issue general injunctions that suspend laws, weakening their power to act as a check on the legislative and executive branches. I say that this reform is important not only because the hyper-politicization of the judiciary threatens judicial independence, but also because federal courts have played a crucial role in the development of the Mexican legal system. As Mexican lawyers know, ever since 1857, the main task of the federal judiciary has been to protect constitutional rights through the amparo suit, the juicio de amparo, which allows any inhabitant of the Republic to challenge a wide range of state actions, from laws to taxes and definitive rulings of state courts. As a result, federal rulings and jurisprudence have historically been among the most important instruments for interpreting and providing uniformity to the Mexican legal system. If the ruling party now has control of lawmaking chambers and the federal judiciary, and it openly announced a political agenda contrary to the reforms enacted over the last 40 years, it is foreseeable that the entire Mexican legal system will suffer a dramatic transformation in the next few years. Taken together, all these reforms entail one of the most radical transformations of Mexico's constitution since 1917. We could spend days discussing the current political developments and the peculiar psychology of our political leaders, but I think it is way more relevant to understand and discuss the implications of the changes I've just summarized. Over the last 40 years, the Mexican and American economies have become deeply intertwined and interdependent, largely due to trade liberalization, shared manufacturing supply chains, and migration flows. The cornerstone of this economic integration was the North American Free Trade Agreement, NAFTA, implemented in 1994, which dramatically increased bilateral trade and investment. NAFTA and its successor, the United States-Mexico-Canada Agreement, USMCA, transformed Mexico into one of the US's top trading partners, particularly in sectors like the automotive industry, electronics, agriculture, and energy. It is essential to realize that this level of economic integration was achieved under a legal, political, and institutional framework that no longer exists. And therefore, we must ask ourselves, how will our shared future will look like under the new rules of the game, both in Mexico and in the United States? This first symposium, Mexican Legal Perspectives, supported by the Mission Foods Texas-Mexico Center at Southern Methodist University, SMU, and in collaboration with the Instituto Tecnológico y de Estudios Superiores de Monterrey, the Robert B. Rowling Center for Business Law and Leadership at SMU, and the State Bar of Texas International Law Section, was designed as a top-level forum to address the ongoing changes in the Mexican legal system, their multiple ramifications, and their effects in the areas that most affect the U.S. Mexico economic relationship, particularly in the Mexico-Texas border. I am positive that the different panels of the program will provide you with a much clearer and informed idea of the importance of these changes for the bilateral economic relationship. I don't want to extend myself more time, so I just want to give thanks again to all of our guests and sponsors, and especially to our colleagues who traveled yesterday from Mexico and from other cities in Texas, as well as to the institutions and organizations that made this event possible, without forgetting the splendid logistical work made by Astrid Galvan and the rest of the staff of the Texas-Mexico Center. Muchas gracias.
Thank you very much, Pablo, for your remarks. Next, we will be hearing from David Salazar, who is the Vice Chairman of the Mission Foods Texas-Mexico Center, and he currently serves as the Vice President of Legal and Governmental Affairs for Mission Foods. Thank you, David.
Ladies and gentlemen, distinguished guests, speaker, esteemed colleagues, Consul Francisco La Torre, board member Alfredo Duarte, good morning. On behalf of the Executive Advisory Board of the Mission Foods Texas-Mexico Center and Mr. Juan Gonzalez, Chairman of the Board of Mission Foods, I welcome you to the Mexican Legal Perspective Symposium. It's an honor to gather here today to explore the dynamic and evolving legal frameworks that shape Mexico's present and future, while fostering dialogue that strengthens the vital relationship between Texas and Mexico. The bond between Texas and Mexico is not merely geographic. It is economic, cultural, and historic. As neighbors, our shared borders represent a vibrant corridor of trade, migration, innovation, and cultural exchange. Mexico benefits immensely from Texas' economic growth and legal stability, just as Texas draws strength from the opportunities and partnerships fostered in Mexico. This symposium underscores our commitment to nurturing this relationship through mutual understanding and collaboration, ensuring that our shared prosperity endures for generations. At the heart of this partnership lies the rule of law, a cornerstone of democratic societies and a foundation for trust in governance, commerce, and civil society. Preserving the rule of law is not a static task. It demands vigilance, adaptation, and dialogue to address emerging challenges, from judicial reforms, as the one that will be discussed today, to cross-border legal cooperation. Today, we will dive into these issues, drawing on the expertise of our scholars from SMU, Tec de Monterrey, and UNAM, practitioners and policymakers, to illuminate how Mexico's legal system navigates these complexities and what it means for our shared future. Over the next few hours, I encourage you to engage deeply, ask bold questions, and share your perspectives. Together, let us reaffirm the importance of a robust legal framework that upholds justice, fosters trusts, and strengthens the ties between Texas and Mexico. Thank you for being here, and I look forward to the insights we will share.
David. Next, we will hear from Ana Pamela Romero Guerra. She serves as the National Director of the Law Program at Tecnológico de Monterrey. Gracias.
Thank you very much. I have to adjust this a little bit. Dear colleagues, it's my absolute pleasure to welcome you to this seminar, the first of what we expect to be an annual tradition. For Tecnológico Monterrey, it is extremely important to initiate and participate in conversations regarding the legal landscapes we face, especially if these conversations involve our students and faculty, since we cannot conceive legal education without analysis and critical thinking. Today, more than ever, we need to reimagine and strengthen the legal profession. At Tech, we are training future lawyers to develop skills that will allow them to break the stereotypes that have harmed our profession. We are certain that our graduates will bring the urgent change that we need through a legal practice with an ethical and modern vision. That's the mission that we have at Tech, to contribute to the advancement of social science, bringing the best of our students to the world. We want to sincerely thank our hosts, SMU and Texas Mexico Center, Pablo, Astrid, Jim. Thank you very, very much for all this effort and your hospitality. We are truly delighted to be here. We appreciate this collaboration, which we are sure will be very fruitful. And please, to all of you, I hope to see you next year in Mexico for the second seminar that will be held in Tecnológico Monterrey. Thank you very much.
Although not on the program, we are going to connect Marissa Sandoval Rodriguez. And we'd like to thank them, and we're grateful to the State Bar of Texas International Law Section for the logistical, programmatic, and financial support. And Marissa serves as the chair of the State Bar of the Texas International Law Section and partner in Cachao Cavazos and Newton Place in McAllen. Thank you, Marissa.
Thank you. I know it's a tough name. So I just want to say that on behalf of the International Law Section of the State Bar, we're honored to be here. We're proud to partner with SMU and EdTech and all of you. We're very proud to support important gatherings like this, and we hope and we look forward to there being more gatherings where legal scholars, practitioners, policymakers, and students all share a commitment to justice and upholding the rule of law and the ongoing evolution of the legal landscape in Mexico and the United States. This year marks the 50th anniversary of the International Law Section, and so I just want to share our mission statement so that you know a little bit more about us, and for any of you who are licensed in Texas, please join our section. So our mission is to develop the practice of international law in Texas, bring an international perspective to the Texas Bar, and help ILS members be impactful and successful in their legal careers. And so events like this help us to do that. So we thank you all so much for being here and look forward to today's discussion. Right, thank you, Marisa. Next, we will transition to our first panel. You should have all received a handout with a QR code. If you have any questions,
please use the instructions there, follow the instructions in order to present those questions so that we can answer them during this next panel. This panel will be, and in a moment, I'll invite our panelists to join me on the stage here. But this panel is on the constitutional reforms, the judicial system, and regulatory agencies. And we will be hearing from Francisca Powell. Yes, please join me. Thank you. Alejandro Falla and our moderator, Eduardo Romero Tago. I will introduce them very briefly. Thank you for joining. Please take a seat. So as I mentioned, I will introduce them very briefly, but invite you all to read their extensive biographies here in the program. So Francisca with us serves as the senior researcher at the Institute for Legal Research at the National Autonomous University of Mexico, known as UNAM, and is a lecturer in law at the Autonomous Technological Institute of Mexico, ITAM. Our next panelist will be Alejandro Falla Rodriguez, who is the commissioner of the Federal Economic Competition Commission and also a professor at Universidad Iberoamericana. And has previously taught at the Universidad Nacional Autónoma de México and the Centro de Investigación y Docencia Económica. And finally, our moderator, Eduardo Romero Tagle.
Yeah.
And it serves as the partner at L. Wagner Henderson. Yours.
Well, can you hear me? Yeah. Thank you so much. So good morning, everyone. First of all, thank you to the SMU Mission Food Center for your kind invitation. There you go. There, much better. Good morning, everyone. First of all, thank you to the SMU Mission Food Center for your kind invitation. We'll proceed with the first panel in which we'll analyze the constitutional amendments that took place last year in Mexico, specifically the judicial reform and the amendment to the regulatory agencies. I was planning to give like a brief introduction, but honestly, I think Pablo Mijangos gave us a quick but master class about the content of the reform. So I'm gonna skip that and we can just jump right ahead into the content of the panel. As Pablo said, after these amendments were approved, it is no exaggeration to say that we now have in Mexico a completely different constitutional dynamic with consequences for generations to come. So, skipping that introduction, thank you, Pablo. Why don't we start by discussing the judicial constitutional amendment? I don't know, Chisca, if you could give us like a quick introduction of its content, its main characteristics. I think that most people tend to think that the judicial reform is only the election of justices and judges, but it has so much more content.
Thank you so much. Yes, I think the content of the reform, which is a challenge, like to summarize all what it implies in a brief time, but there are like three main clusters of provisions. The first one and the most relevant and consequential one is the total replacement of the current the dismissal of the entire judiciary in Mexico, both federal and the 32 state judiciaries, all levels, and the replacement with new judges elected through a system of popular vote that I will then briefly give some details on, but just let me put that in two batches, like more or less half of the judiciary in 2025 and the other half in 2027. So in this short period of time. So it's not a gradual replacement. We have known, for instance, about the gradual reforms in places like Hungary, for example, where you, for instance, lower the age of retirement and like kind of seek a partial, this is not this thing. It's not a reform because this had been a lot of talk about Bolivia in Mexico, but in Bolivia, only the high courts are elected, only the 3 high courts. This is the entire judiciary, all levels. And there's a lot of this analysis as well with the U.S. local elections. Some of the U.S. states have elections for local judges in an environment, in a legal environment that has nothing to do with the Mexican one, with far more civilized in terms of applicable law, case law, etc. If you are interested, then we can explore these analogies. So this is the first cluster. I will go into the details, some of the details of the election right now, but let me describe the second group of provisions that concerns organic changes, we could say, in the structure of the Supreme Court and other ethics institutions. As Pablo was advancing, the Judiciary Council disappears and is replaced by 2 different institutions. An órgano de administración that is not elected. The only one that is not elected is appointed in an inter-branch collaboration model. And then the discipline court, that is one of the institutions that is more, problematic and worrying, because the jurisdiction of this disciplinary court, that is also popularly elected, is described in super broad terms, in open-ended terms. So basically, they are in charge of supervising and punishing judges on the basis of an open-ended jurisdiction that can be chilling in many respects. And there's not a challenge against the determinations of the discipline court before a different institution. It's only, you first have a panel of 3 members of the discipline court, and then you have an appeal to the plenary of the same institution. So not really an appeal for me. So this is one of the other changes. For instance, the chambers of the Supreme Court disappear. And you might say, well, it's okay. I mean, there's the plenary. But as we can then describe, most of the work in the Supreme Court, the Mexican Supreme Court is not like the U.S. Supreme Court with a certiorari system, only looking for, a few cases each year. The docket is huge. And most of the things are done in the chambers. So we really don't know what will mean to do, then I can give you the numbers if you want to see everything in the plenary, streamed in public, so this looks like a minor change, but it is not. And then, well, the number of justices goes from 11 to 9. And another important thing in the organic restructuration is that the trust, los fideicomisos, the trust that up to now were giving financial security and independence to judicial personnel had been eliminated. So this also looks like small, but it's not. The third group of provisions comprises a few minor procedural changes altering how cases are processed and the effects they have. For instance, deadlines to adjudicate certain cases, limitation in the scope of precautionary stays, limitation in the remedies, the creation, this is very problematic as well, of the figure of faceless judges, jueces sin rostro, which is something that has been declared contrary to human rights by international human rights courts. And a general prohibition of interpretation that for lawyers is a bit fun, of course, but it is very telling about the understanding of the relations between the judiciary and the other branches. So there's this general restrictive view on, having the judges do as small as possible. In terms of the election, it is all very long. I don't want to take, but I will speak more on this topic than on the others because it is so gigantic, the new regulation. But just to give you a sense of how the election that is now, now the campaigns are underway, how it is organized, and why it is worrying in many respects. There are like 3 stages in the, in the selection of candidates to the election. Now, I will describe only now the regulation that applies to federal judges, because the state judiciaries are also replaced, but they have to amend the constitution. Actually, they have already amended the constitutions. So in parallel, we have different models of state elections going on, but I will just describe the 3 stages in the federal election that are with all that detail in the constitution, that our constitution is super detailed. So all that I will say, it's there, regulated just there. So there's a first stage of basic qualifications to be fulfilled by the candidates to be judges. And the basic qualifications are super, super low. There's really not a lot of requirements. You have to be a natural born citizen. You have to have a certain point average in any of your degrees. It can be the licenciatura, it could be a master's whatever. You have to have 5 letters from your neighbors saying you are a nice person and appropriate for the job, and a 3-page essay explaining the motivation to be a judge. No legal experience is required to be a district judge. 3 years of legal experience in any area is necessary to be a magistrate in the circuit courts, and 5 years of any kind of legal experience is necessary for the Supreme Court and the Electoral Court. So this is the first stage. Then let me tell you, to filter all the people through the stages, the 3 branches had to set up a selection committee composed of 5 persons, only 5 persons working pro bono. I mean, this is important because you will see the thousands of candidates that this had to, and the results that we have is that because the job was simply not realistically possible to be done by 5 persons that have no salary for their. So after the first stage, you would see if the people would require, the letters of the neighbors, the average point. And then there's a second, like, suitability stage selection, a kind of long list, not short list, but a kind of intermediate list, where the committees would rank the candidates according to the merits of the trajectory. They could select whatever methods they were willing to use. So most of the committees use basically an interview system, and then come up with a list of 10 candidates for each post in the high courts, and 6 names for the lower post. And then final draw, sorteo, I don't know the best translation, a final draw to discard the surplus of candidates was done. And so finally, in the ballot, we have like each power branch selecting 3 candidates for each of the vacancies, and in the lower courts, each branch selecting 2 candidates. So the numeralia, I don't go into the numeralia, but you have to be thinking of, for instance, now the Electoral Institute is printing how many million ballots? I have the thing here. 600 millones, I have problems to say the numbers in English. 600 million ballots are being printed now, 8 million ballots a day. I mean, I won't go into the numeralia, but it's this kind of numeralia. It is only like to think about how we are paying this. I mean, the cost in millions of dollars, I also have that. The Electoral Institute had asked for $640 million, o sea, 13,000 millones de pesos, to organize, and it was given half of it. It was given $307 millones. But just to give you a sense of the giantism of this. Then to end, a campaign must be done. So now the candidates that survive the 3 stages are doing the campaign. The campaign, you cannot receive neither public money nor private money. So basically no money. And if you have money, the Electoral Institute set a limit to the amount of personal money that the person can invest. So basically the campaigns are in the social redes sociales, WhatsApp and all these kind of things. And and in June we will finally, another last important point of organization, which is crucial. The votes in the judicial election won't be counted applying the standard rules that have made of Mexico a democracy, right? Which, as you probably know, imply that it is citizens that are on the voting stations and count the votes and put the list of the results in the streets, in election day. And then, so it is a very ciudadano system that's based on the control of the elections. And this was crucial in Mexico, because we didn't have a formal military dictatorship, but we had elections that were not reliable. How we build reliability through this system of citizen administration of the elections. For the first time, the citizens will not count the votes. Why? Because the votes are, the amount of ballots and the amount, for instance, in Mexico City, the amount of leads and ballots and everything, citizens would, the Electoral Institute says that citizens would have to spend days. You know what I mean? In terms of, So the citizens will only separate the ballots for the different justices, the district judges, will separate the things out of the votes, and then the votes will be counted in the Electoral Institute delegations. And the spare ballots, this is also very important. I've been a funcionaria de casilla. This is why I can describe, I am a double national, so I'm Mexican citizen as well. After the election in standard times, you nullify the ballots that have not been used. Because of course, on the pre, sometimes there was like you would feed the ballot boxes. That was embarazar las urnas. So in the standard elections, it is a very important guarantee that you nullify the spare ballot so that nobody can use it. The spare ballots will not be nullified this time. So this is also very important. It is all very worrying because the logistics look really crazy and we can speak about what happened with the candidates. But basically, I think this is some of the things that you should know about what the election means at the federal level. And I don't have time to go into the state ones.
Thank you. Alejandro, I don't know if you could also give us like a brief introduction of what the Regulatory Agencies Amendment encompassed. I know that you're going to focus on the Economic Competition Agency and antitrust matters. So what could you tell us about that reform?
Thanks a lot for inviting me to this therapy session. I was really worried about many things after hearing Francisca. I'm seriously depressed now. I knew that the judicial reform was really bad, but when you go into the details, it's really shocking. Elections are being poorly organized, and we cannot expect good things from this reform. I mean, we can conclude fairly that independence and the technical capacity of the judiciary are seriously compromised now. And the bad thing is that this is not the only reform, and this is part of a package. Some reforms are meaningless, like forbidding debates in the Constitution itself. But there are other reforms. I mean, I think this is the worst of all of the reforms, because we are talking about this mantling of one of the main powers that are part of the Mexican state. But I'm also worried about the regulatory reforms. And we have an impact that will be magnified by this combination. There is a radical transformation now in the way the regulatory state model in Mexico had been constructing in the last decades. And this is part of the natural evolution of states. And not only Mexico, but also in Asia, Europe, Latin America. The states, in terms of its administrative and public policy organization, were centralized, and all the power was concentrated in the president, in the ministries. And we've been moving towards a more decentralized system based on modern techniques of public policy, using regulators, technical institutions, autonomous bodies, bringing civil society into action, judges with a more proactive role. I mean, that is what we can expect from modern states in general, but in Mexico, now we are moving backwards. Yes, I will focus on the antitrust agency, but I can say, as part of this reform, 3 constitutional autonomy bodies have been wiped out. We're talking about the National Institute of Transparency and Access of Information. That is a main institution because it guarantees the human right of access of information. The Federal Institute of Telecommunications, which is the telecom and broadcasting regulator, and the antitrust agency, where I still serve as commissioner of ESE, the Economic Competition Agency. And we have also 2 energy regulators that were already part of the government, but they were organized as autonomous technical institution. Now the reform also diminishes its legal stature, and these regulators are being absorbed by the Ministry of Energy. So we can see what is the common objective of changing and disappearing and getting rid of some institution. This is all about centralizing functions within the government, and we should ask ourselves if this is a good technique, if this is getting good results for society, and I can make some insights about the antitrust regime. In terms of antitrust, I can say that until this reform, we had 30 years of a competition regime. I mean, there is a history of a competition regime. The US has more than 1 century. Europe started constructing its competition regime after the 50s, in the last century. I mean, we came after, but still, we're talking about 30 years of history of competition regime. And we could see a common feature, a continuous improvement of the system, a continuous strengthening, with a particular emphasis in the design of the authority and its autonomy conditions, its budget, human resources, technical capabilities. That had been the constant, because the first antitrust agency was born back in 1993. And let me say that this is a crucial institution for Mexico, because we have a highly concentrated economy with a lot of competition problems. And for a market to work efficiently for the benefit of society, we do need a lot of competition, and we need institutions that advocate for this value. It started as a weak authority, but it grew a lot thanks to legislative reforms, thanks to more investment in terms of money, people, in terms of judiciary resolutions that gave more powers to the authority. And in 1913, I mean, a little bit more than 10 years ago, there was a political decision to keep full constitutional autonomy to the antitrust agency in Mexico. Why? Because there was a consensus at that time between the main political parties that we needed a big leap. We needed a substantial progress in the regime by giving a lot of power to the institution. And in order for this institution to be credible, to be effective, constitutional autonomy was granted. And maybe that will be part of another discussion, but and of course I am biased because I am a commissioner, but I think this more has been very successful in terms of objective indicators and criteria, in terms of number of investigations, historical finds, advocacy actions that led to very good reforms of laws and regulations and policies and administrative practices. And I can have I have a lot of data and many examples. And now there was a big reform, a big chunk of Article 28 of the Constitution was eliminated. All references to COFECE are out, of course, and now there is a brief paragraph saying that competition policy and this function of investigating and sanctioning cartels, abuse of dominance, anti-competitive practices will be conducted through the executive. And there is a transitory article stating that there will be, and this is a good part out of all this bad news, there is a brief mention that there will be an authority with technical independence that will conduct competition powers. In Mexico, this authority will be sectorized, will be related to the Ministry of Economy, And there is an idea to construct an authority in similar terms as COFECE is currently organized, but that remains to be seen. How bad is this? I mean, is it really bad to eliminate an authority that still works as an autonomous constitutional body in Mexico and transfer the function to the hands of the central government? I would say if this were an isolated event, it would be different. But as I was mentioning earlier, this is part of a package. A lot of functions are being eliminated. A lot of functions are being transferred to the central government. That is contrary to the natural evolution of the states. That is combined with a political atmosphere, which is highly dependent on one political party. So all the combination points to a really bad direction. So the problem is threefold. Why? First, because we're moving back. So as I was telling you, 30 years of strengthening the competition regime. Now we are getting rid of constitutional autonomy, and the president is talking about investing less resources. Politicians tend to say COFECE is highly expensive, so let's invest half of resources. What they don't say is that we impose like 10 times more fines than the budget is allocated to COFECE each year. And those fines go to the federal treasury. So it's a really bad decision for them in terms of financial interest. I mean, if I were them, I would say I would put more money into a body like this because it gives me more tax returns in terms of the sanction authority it has. Second, there will be an inevitable institutional loss in the transition. Why? Because could be a mess. I hope it isn't. But when you transform radically an institution that had been working fine, just fine, and then give it a different status, there will be a loss. We have a lot of current investigation. We have a lot of cases. We have a lot of human talent. We have a status that will have to change. There will be a lot of amendments. So I'm really worried, and I hope this really won't happen. And three, even though the Constitution talks about technical independence, we have to wait and see because there will be a reform to the competition law, and this technical independence has to be respected politically, not because the Constitution says that an authority will be technical independent, it means that it will be. There has to be respect by the Minister of Economy, by the President, and until now, COFECE is one of the very few Mexican institutions that is fully independent and that it operates 100% with technical criteria. So when is this reform coming into force? I don't know. It depends on the reforms to the competition law. This competition law initiative has been filed by President Sheinbaum just 2 weeks ago. I can talk about maybe in a different question about the main features of this reform. And maybe once this reform gets approved and published in the Federal Register, it's supposed to enter into force this competition reform. All commissioners will be gone. I will be teaching or doing something else, consultancy, traveling maybe. And one big worry that I have is that we were appointed through a very rigorous process. I had to pass an exam. I had to fulfill requirements. I had to be proposed by an evaluation committee. And now 5 commissioners will be discretionary, appointed by the president and approved by the Senate, which has a supermajority approved by Morena. So I also hope that they are responsible in the process of appointment, because the technical rigor and independence of an authority starts with its board of directors. Thank you.
Hey, thank you, Alejandro. Now, there are 4 different topics that I want to talk about before we move to the question from the audience. I think the first one is both amendments were a product of a diagnosis from the past administration and the Congress. Now, maybe we would not be happy with the current amendments, but I want to focus on the diagnosis. Was there actually something to correct in the judicial system, in the regulatory agencies? Like, there was something truthful in the diagnosis? Like, was an amendment needed, even if not these amendments that we have right now?
Well, there was not a technical diagnosis on their part. What the people that we have been studying the judiciary in Mexico for a lot of times have a diagnosis in mind. But it's not, this is one of the things that has been discussed. There was not real diagnosis. So if you ask me personally, I can give you my diagnosis.
Sure.
It's not that there was a diagnosis over there. That's one of the problems of the reform. I think there were, of course, many things to improve. I mean, we made our academic living on that. But the thing is that this is why it is so desperate, the opportunity cost of this reform, because none of these problems is addressed in the reforms. You know what I mean? Of course, there are problems, but then you have a reform that I will explain why I think does not target any of these problems and creates new ones. It's like, oh, it's super cold. Well, let's put calefacción. No, I mean, you know, like it goes against what were the main problems for me? Well, let me tell you that if I will never be president, right? But I wouldn't have started with the problems of the judiciary. I mean, you know, in Mexico, we have problems in terms of disappeared and violent murders, and we have economic problems, and we have, you know, all kinds of problems. So I wouldn't have started as a president with it, because in a way, you need a strong judiciary to deal with the other problems, you know? But in the judiciary, I mean, I think the federal judiciary had been improving a lot since the 90s in this gradual way. That's what Eduardo was describing for other institutions. But of course, the state judiciaries, for instance, had to be reinforced. I mean, they were still a bit too much influenced by governors. So there was this, you know, this thing about state judiciaries that needed more money, more professionalism, etc. So I would have started by reinforcing a little bit the state judiciary. But the first thing, the prosecution, that the prosecution is basically the responsible for the figures of impunity in Mexico. It works very badly. When, you know, investigations reach the judiciary has to give an amparo, because the prosecution, you know, the prosecution in Mexico was never reformed in the 90s. In the, you know, in all these reforms that in a way like put the ground to the process of democratization and modernization, etc. The prosecution was left outside, and it works very bad. So, and this has been a problem because many people out there don't know the difference between a prosecutor and a judge. Like, you know, like for people, everything is smart. And of course, people perceive that the system works very badly, but many of the problems we have are tied to las fiscales, to fiscalías, state and federal, and fiscalías are not touched by the reform. Another problem, of course, is access to justice and simplification of both substantive law and procedural law. I mean, and this has been a problem for the judiciary because we have, you know, just to pick up the hyper famous amparo, no? Amparo Mexicano, which is a kind of, you know, even a cultural kind of item, but it is very complex. I mean, Amparo habeas corpus more or less works, but in many respects, those of you that I know, you know, the Mexican legal system in many respects is very baroque. It's very contorted. And for many people, there was not enough use of the system. Many things are dealt informally in Mexico, not only in the economy, also in the adjudication dispute resolution. So this has been a problem because, for instance, if you have this bomb, no? In Colombia, I think people like go to the streets and say, well, no, keep your hands out of my tutela. Tutela is, because they have been like receiving more benefits from daily access to justice. And this was a problem in Mexico. I think in the federal judiciary, things were working really well, but it was not sufficiently plastic for people. And so one of the things that we had been arguing for many years was, well, just let's try to really like make justice more available to people on a daily basis, right? So this is another thing that I would have like changed.
So,
And well, a last point only because the government has said a lot that it was corporativism, like too much. But this, it might be that it was, for years we had said that we had to fortify the lateral entrance to judiciary. The meritocratic system, many of the contests were open for the people already working in the judiciary in the lower ranks and going up. So yes, you had to fortify lateral entrance to the judiciary. But of course, this is a very specific reform that you can do to like open up more the kind of people that gets into, which is not necessarily these high class people, nothing, because but so this is, I don't know, of course there were things to improve. I don't think any of them will be improved by this.
So I'm gonna just jump right ahead and maybe the toughest question that I have, maybe. Do you think there's some positive aspects of the amendment, in your opinion?
It is very tough for me to see a positive aspect.
No.
Because there are people that say, well, that, kind of defend the disruption theory. You know what I mean? It's like, well, the shock theory. I mean, this is such a great shock that, we are going out of gradualism. But I really can't see because you kind of throw over the board what we have gained. It was insufficient, but I don't see what we are gaining.
Okay.
And even there's a lot of variety in the candidates, as you can imagine, because there was even not material possibility of screening. But even imagine some of the candidates are okay, how they will handle with a system with so much. Well, we can talk about that, how this will work, or we can like kind of.
Yeah, we could even present some of the social media posts of the campaigns, right?
I will keep your question in mind, but it's tough for me to see something. Yeah.
So Alejandro, what about the diagnosis in the regulatory agencies and the economic competition area? Was there something truthful about the diagnosis?
So at least in our case, it happened something similar than the judiciary initiative. There is not a diagnosis. I read the exposición de motivos, and there was a very simplistic argument that I've heard over the last 15, 20 years when somebody wants to criticize the antitrust agency. There are still a lot of monopolies in Mexico. We have a lot of big companies, okay? That is also the case of the US, that is also the case of France. There are a lot of competition problems in Mexico. We have very high prices of food, energy, medicine. Well, the answer in terms of only policy, if you are a little bit informed, is that competition depends on many, many things. An antitrust agency does just a very small specific part, which is investigating anti-competitive behavior, imposing sanctions, reviewing mergers and acquisitions. And those tasks are supposed to be performed under clinical criteria, because otherwise the investment atmosphere, the investment climate will be distorted. That is why it is highly important the competition agency is neutral, technical, free from political bias, private interference, because otherwise investors are going to be worried. Investment decisions will be distorted. So competition depends, as I was telling you, on many variables, mainly on the rules of the game, on the laws, regulation, public policies, competitive conditions, entry conditions, operating conditions. So when I was in some discussions with congressmen over the last 10 years, and they were criticizing why we have a lot of competition problems, I was telling them, well, because mainly you have to reform this law and that law. The government of Nuevo León has to do something. So the argument was, in principle, in paper, oh, we have a lot of competition problems. So yes, I know, and it depends, and it is up to many authorities to resolve progressively this problem. So it was just an excuse. I mean, I think that we all know that there is a misleading notion, an idea that I still do not understand, that the antitrust agency and some regulators are out of this malign neoliberal vision of reckless free market economy, and on the contrary, regulators and the antitrust agency are part of the regulatory state. A left-wing government should embrace this means of intervention, because they're supposed to put a halt to the abuse of economic power. So there was not a diagnosis. I think that reading the agenda, somebody, I would expect support to these kind of institutions instead of its weakening. So I think that COFECE over the last 10 years can show a very, very good outcome. In terms of historical finds, I was telling earlier to big companies that were never touched before, in energy, in food, in medicine, in transportation. We have the record there. And we reviewed more than 1,500 mergers and acquisitions, and I haven't heard anyone pointing to a single decision that was tainted by a political interest or by any interference of an economic agent. So, of course, there was, and there is, space for improvement in many specific aspects. And of course, there are a lot of things that we could have done better, but the solution was different. I mean, the solution was to amend the competition law, to strengthen the authority, to put on the board more resources, because we have a very big economy. It's one of the main economies in the world. And I think that radically transforming the model we have been constructing was not the answer. There was a lot of things to do, of course, for us, especially for others. And there's nothing good, in my opinion.
I was going to make you a question. Yeah.
From the Constitution, there is nothing good, in my opinion. I didn't come here to be politically correct. But, and I'm leaving anyway, so it can say whatever I want. But the only good thing that I can rescue is that I was reading the proposal by President Sheinbaum, and I was really worried that not only the constitutional autonomy was to be dismantled, but also that the competition regime, in terms of its substantive and procedural aspects, were to be downgraded. But no, I mean, there are sanctions will be increased. The statute of limitation is going to be longer. The main aspects of our foreign competition law will be preserved. There will be more powers to the agency. So most of these things are good, only if the new authority is properly
Technical.
constituted and it operates with technical independence as mandated by the Constitution. If this doesn't happen, I will be, if I were an investor, deeply worried that we are having now a more powerful agency with no technical independence. So That is the only way food. That is the only good news, but it depends on how the new agency is organized and how the new agency resumes the works previously done by COFESE and the people that will be working there and the expertise and those factors that make an antitrust agency a good institution.
So I want to ask you a question with two different aspects or topics before we move on to the question from the audience that we're just receiving a few of them very interesting. So, I mean, it's clear that, I mean, the short term, at least, there's not going to be a constitutional amendment reversing these changes, or it doesn't seem like that's going to happen according to the current political context. So what about the international reaction to this? There has been a ton of discussion on whether both amendments are a violation to USMCA, sorry. So what do you think that's going to be the reaction of the international community? Is this actually a violation to international treaties? And the second aspect of my question is, do you still think that Mexico will be, in the short term, a proper forum to solve controversies, issues, cases, or it is time for investors to start looking for some other proper forums, such as international arbitration, even under USMCA or under ICC, or some of both those other arbitration authorities. There's even the chance of litigating in federal courts in the US against the Mexican government under certain requirements, but it's a chance, a possibility. So what do you think is going to be the reaction of the international community?
Well, I'm not an international lawyer. There are some of them in the audience and many people with more knowledge. But well, there are some things that I can tell. Well, first, of course, this will be at some point declared unconventional by the Inter-American Human Rights Court, because the global dismissal of all the judiciary, you know, with the precedents we have, etc., and with the criteria on independence that human rights courts hold, this is incompatible. So this we can say. As to the USMCA, as you know, like for the past 3 years, there was a huge reform in the labor courts in Mexico, just to comply with the, the agreements before the USMCA. The labor courts in Mexico were part of the executive. Remember the juntas and all that. And of course, the USMCA presupposes, like implies that the labor courts are independent. So you could make an argument, saying, let's see if now we fulfill these things. But of course, we don't really know what will happen with USMCA, right? So it is under. So I think, of course, there will be ways, no? Arbitration, I'm not a specialist in arbitration, but everybody seems to have this super hope in arbitration. And of course, probably investment arbitration will go more or less the same way, the things that happen in these panels outside. But as for commercial arbitration, I am not that sure, right? Because, well, again, if the state is involved, there are separate provisions in the treaties, but as private arbitration in commercial terms, in Mexico, you have this regulated in the commercial code, ley arbitral. And yes, the regulation on arbitration gives a very constrained role to the courts, very constrained, but there are grounds to set aside an arbitral award. And there are, sometimes you have to go to court to execute the award, as you know. And this is designed to be very restrictive. And the Supreme Court, the destituted Supreme Court, has case law saying that of course judges must be very differentes, no? But this presupposes that the judge wants to be like that. This presupposes that you have a judge that knows how the relationship between the judiciary and arbitration should be for arbitration to work well. You know what I mean? So I think everything is very unpredictable, because I think people assume that, we will bypass this. In Mexico, no, Gato Pardo, everything changes, but everything will stay the same. Crony capitalism, whatever. I'm not that sure. This will be very chaotic, right? And at some point you meet the Mexican judicial system, and we can't really like know what will happen. Maybe the government will, if chaos, installs, maybe the government, I think it's very difficult to reverse this through constitutional amendment. Again, now with all these apparatus that they put into place, it was possible in record time, but with a lot of maneuvers that don't even want to describe, to get this approved in record time in Congress and then in half of the state legislators. To do the same under different circumstances would be very difficult. But maybe we could, decide to create some new courts, like more reliable, less. I mean, of course, we can think about ways out, you know what I mean? Or, for instance, this applies to all the courts that are within the judiciary. They could kind of create a rare animal, like, to bypass and create, but it's very difficult to know. But I don't think this arbitration thing is as neat as it could be. Maybe in ordinary cases, I don't know, but who knows what the ordinary cases are.
Yeah.
But if there are like strong interests in a few cases, I don't know. But even if the government is interested in preserving some areas of litigation of commercial or investment or whatever, well, this is unfair for the rest of the people that has a system that has without guarantees of working better than before, just the contrary. So no say, I don't know. I have run out of optimism at this point, even if one tries to see how this can work out a little bit. But
What do you think, Alejandro?
About what?
The international reaction to that, specifically this topic, and whether, for instance, controversies and cases that, currently are handled by federal courts in Mexico. Like, is Mexico going to be stopped to be a proper forum? Should we start looking for other forums like U.S. litigation, international arbitration, specifically in economic competition?
I love this arbitration discussion. It's part of my former life when I was working at the Ministry of Economy. Actually, I was in charge of the negotiation of bilateral investment treaties that include a chapter on investment state arbitration. I pretty much agree with what Francisca just mentioned. Everybody has the hope of using arbitration across the board. I mean, that won't be the case because arbitration is always a residual forum. And it much depends on the judiciary because at the end of the day, you have to enforce on the word. Investor state arbitration are exceptional cases. We have just a few of them around the globe, and I won't point to those cases. Mexico will be a forum because it's a great investment country. It's one of the main recipients. China, for instance, everybody knows it's a lot of problems. But investments have been flowing into that country for decades. Why? Because it's a huge economy with a lot of opportunities. I mean, right now it's having a lot of troubles, but Mexico, it's a great country to invest with a lot of problems, with a lot of risks, but that is part of an investment decision. This is not helping, of course, because the investment climate is strengthened with the rule of law. That has been and will still be more than ever a challenge for Mexico. That is, I would say, the main objective should be for politicians, for policymakers, to strengthen the rule of law. That is our main goal. That is our main challenge. That will change everything. And of course, this is not helping the reform to the judiciary, administrative bodies. In terms of international obligations, you were mentioning UMSCA for everybody, but the treaty, it's a very ugly name. It used to be NAFTA. Now it's the treaty between Mexico, Canada, and the US. That's a quite boring title for a commercial treaty, one of the main commercial treaties in the world. it has a many people doesn't know it has a competition chapter. I was in charge of that negotiation, and I'm very proud of it because we agreed, the three countries, to set a floor in terms of due process, procedural fairness, and cooperation between three countries, and that cannot be reverted even by the Constitution because it is an international obligation. So we have been insisting that the law that will be currently discussed and the way it will be implemented by the new authority with the good or bad influence of the government have to comply with these principles. The reform of regulatory agencies, at least when it comes to COFECE, does not in and of itself violate this treaty, but it jeopardizes its compliance because now we have very robust, very transparent procedures for mergers, acquisitions, public biddings, investigations, so on and so forth. And the new authority will have to reorganize everything. We'll have to design new procedures when there was not a need. And if in the way due process, procedural fairness are compromised, there could be an implication in terms of scam. Just to conclude, Mexico is still Mexico. It has a very dynamic, vibrant, big economy. The forum and cases and litigation inevitably will still be developing. And I don't know, I mean, I don't know how to mitigate the impact of this reform. And I'm worried that we'll have a second election in 2-3 years. And maybe the main question is not if this will be reverted, if we can organize a better election maybe in 2 years, if everybody can say, let's suspend the election maybe for a while. I don't think that will happen. But maybe our eyes will have to be watching what happens in the following 2 years.
Yeah. So we just have 5 more minutes, so I'm just gonna go right ahead to the questions of the audience and invite anyone else that has a question. There are 2 very interesting questions, and please, I would appreciate a short answer to so we can talk about as many questions as possible. The first one is, considering gaps identified in the judicial election process and candidacy requirements, how might organized crime try to take advantage to accrue influence through the judiciary?
Yeah, well, there are already problems with some of the candidates that the government itself has identified. So there was not material time to really scrutinize, and also the requirements are very low. So so now I don't know if you saw in the papers, in the Mexican papers, that the government has asked the Electoral Institute to take down candidates, but at this point it's not possible anymore, right? Because the names are on the ballot. So yeah, this is one of the concerns, that there was no, this is so massive. It's thousands and thousands and thousands of names, literally. Just for you, it's not like the U.S. local elections, 2 or 3 candidates for each post. And so yes, from the beginning, when this was about, one of the things is that we thought it wouldn't be possible to pass this because of this, how you control that, that very powerful groups. Of course, lack of political independence is a problem, but lack of independence from other groups in society, among them organized crime, is also a problem. And yes, so the government itself is worried by candidates that have been associated to organized crime and wants to take them down. But there's no easy way to do it now. So we don't know what will happen after if they get elected. We don't know.
So the next one, very interesting question is, it seems that a similar system is working in Texas and in other states, actually. in the US, where judges are elected. Why is this change in Mexico concerning compared with its system in Texas?
Well, because in the US, federal judges are not like that. Because the amount of candidates, I mean, yeah, I know you have elections, but even if people don't go into the big bios very often, whatever, you can do it. I mean, I don't know how many candidates you have, but it's more or less manageable. Things that we will have only for federal judges in Mexico City, like 6 ballots with dozens of names, just the names, and then the state one. So there's no way, meaningful way to get an informed vote about this. On the other hand, I don't know the Texas in detail thing, but to my knowledge, most of the elected judges in the states are trial judges. With this adversarial system, well, I don't know, the role of the judge is not as powerful in the, you know, in how things turn out. The amount of things that you have to handle in terms of both the law and the facts as a judge, there's no juries in Mexico. So really, the judge has a very powerful role that I think here is more constrained. But here also, the law constrains more judges because you have a very strong precedent system. And I don't know, I think we can point out problems, but I think they are kept within like margins in the US. And all these margins like go crazy when you see, you know, and also you replace judges from time to time in some of the states. We are now replacing the entire judiciary, you know, like the scale of the thing makes it very, very different. Well, I forgot to say that current judges can participate in the new system. But of course, most of them have just resigned. Some of them have decided to participate, but we don't know if they will be able. Many of them will not like reach. Well, they have a special regime that they can reach the ballot more easily than the natural candidate. But of course, for every post, I think it's like 9 candidates, 6 candidates, depending on the.
Yeah.
So this is a great debate. These analogies between Mexico but I think there's a lot of these analogies. And just keep no, the radicality of doing everything at the same time, but in 2 batches. I don't know. I think it's super disanalogous.
Well, I'm just gonna invite everyone to see if there's some further questions. And if not, I think our time is over and this would be the conclusion of the first half. So thank you.
Thank you. We want to thank very warmly our panelists, Francisca and Alejandro, for sharing their expertise with us. It was a very thought-provoking discussion, and thank you, Eduardo, for facilitating it. Right now, we will have a coffee break until 10:40. It's out here in the hall. And we're excited to welcome you back for our next panel of Unpacking the Energy Reform, its legal implications across borders. Thank you.
You need to tell the people.
Yes, yes.
Again, I'm, you're all medicine.
All right, so I have the table, the production table. So you can follow the sign. Yeah. Okay, there's something. What did you say? Just walking. Yeah. No, no, actually, our new assistant right now is Courtney Coons is coming up. She's spoken online. Yes, yes, actually, we're connected. Oh, it's connected. I know. She has no, it's not in the morning, but not the morning, in, I want to say. No, no. I held our conference last Friday, and so I know Believe me, I like to see just everybody show up. Everybody. All right, that's water for you, and let me bring you some pens, all right? Thank you.
Everything's right. So, yeah, for the conversation. You already have one example, you can set up your own. There's one professor it's crazy that we need the whole time basically makes it size of different relationship, interesting common, especially here in Dallas, there are a million Mexican nationals living here in Manhattan. So it's like we need definitely.
All your work are gonna change.
Okay. So you choose the questions. You see what are interesting for you don't necessarily Good.
Ubicando todos los. Voy a quitar el mute. Ya vas live. 5, 4, 3, 2.
All right, thank you. We're gonna reconvene for our next panel. We hope you enjoyed your coffee break provided by the International Law section of the State Bar of Texas. And they also have an announcement that they want us to share with all of you that This event has been improved for 3 hours of CLE. And I have the number here, but you can also receive the number at the front as you walk out if you would like those credit hours. If you'd like to jot it down very quickly, the number is 174. So 174-280-837. And again, as you walk out, you can get that at the front. I'd also like to take a moment as we reconvene for our next panel to thank our name donors profoundly for making this event possible. So thank you, Mission Foods, for being here and for supporting us and allowing us to have these very important discussions that we hope will serve as a catalyst for making very important change. So thank you, Mission Foods, for making this possible. Okay, next we're moving on to our panel that is on unpacking the energy reform, its legal implications across borders. For this panel, we have with us Luis Alberto Sierra Barragan, Juan M. Acala, and Monica U. Herman. Okay. A little bit about Luis. He is the Associate Dean of Research and Faculty Development of the School of Social Sciences and Government of Tecnológico de Monterrey. And Juan M. Acala is a trial attorney and partner at Holland and Knight LLP. And finally, we have our moderator, Monica U. Herman, who serves as a professor of law at the SMU Dedman School of Law. So thank you very much for this panel, and the time is yours.
Hi, can everyone hear me all right? All right, thank you so much, Courtney. Thanks for those introductions. Huge thank you again to the Mission Foods Texas Mexico Center, Tecnológico de Monterrey, the Rowling Center, the Dallas Bar Association International Law Section, and everyone here, Courtney, Astrid, Pablo, who make these events possible. This panel, we are going to delve into the wonderful world of energy. And with respect to the Texas-Mexico relationship, there probably isn't a bigger sector that is more important, more central to economies than energy. And so with our panelists today, we have a sort of four-part conversation that we'd like to have. And along the road on that conversation, I would encourage you to think of any questions, and we will take those questions probably the last 15 minutes of this session. So energy governance in Mexico has swung, as we've seen, between state dominance and then liberalization, and back now to a sort of state-centric model. So there is a reassertion of state role. And what this part of our conversation, this first part, is the sort of historical role. Let's place the history of these past conversations, in particular the 2013 reforms, so that we can think about the impact now of the 2024 and 2025. The second part of our conversation will focus on legislative, regulatory, and judicial changes. Panel 1 gave a phenomenal oversight on sort of constitutional work. And then part 3 of our conversation are market reaction and impacts. So from a private investor, from any type of partnership model, from these aspects about pricing, in addition to goals such as climate change, energy transition, which has been a big focus of the Sheinbaum administration, we'll have some discussion on those areas. And then lastly, we'll look at international and cross-border implications. So I want to welcome our distinguished panelists. Thank you so much for your time. I'm going to start one with a question for you now. So thinking about our sort of historical perspective and where we were, particularly with respect to the 2013 reforms, from a legal and investor perspective, what did those prior reforms represent, and then how were they received?
Well, Erica, thank you so much, and I echo your thanks to various sponsors. I also want to thank Eric for the presentation. Really appreciate that. To answer your question, it was big news, right? So most of you, I think, are familiar with the reforms that happened in 2013. So I'm not going to go into too much detail about that. But for those of you who may not be familiar, right, this is taking us back to the presidency of Lázaro Cárdenas, right, back in the 1930s, and really the 1917 Constitution, right? So that set the precedence for the discussion that we're having today. Because until 2013, the the energy sector was closed to a lot of private investment, especially foreign investment. And so 2013 comes along, and this revolution, right? And in many ways, where the Constitution was amended, and there was an opening of the hydrocarbon electricity sector, particularly to foreign investment, a way that had not been the case before. And so a number of secondary laws were created that created some significant incentives for private participation, especially by foreign companies. And just following up on a discussion from the prior panel, some of the discussions that Alejandro was providing, right? There was very strong anti-monopolistic laws and regimes that were secured. And so that set the stage for foreign companies in both the electricity and the hydrocarbon sector to flock to Mexico and try to be participants along with Pemex and CFE, the electricity company, and really take advantage of that opening of the market and the demand and the need that existed. Because it wasn't just a matter of, oh, there's new laws, there's an opening, but there was a huge demand. There's a huge demand. And there were also issues that were trying to be solved, issues that Pemex and CFE were having. So that's a little bit of the background. It was incredibly welcome news. It was big news back in 2013. But that was then, this is now.
And Juan, thank you. Oh, sorry. Juan, thank you. Luis, do you have anything to add to that perspective then?
Well, yeah, first of all, thank you again to the sponsors organization, Pablo, Pamela, thank you for inviting us and having us here. And just a brief comment, a word of advice, I'm probably not or the only non-lawyer here, so it's going to be a different perspective, but I guess that it's precisely in the energy sector, it's a sector where all disciplines gather. Well, I just have to say that in terms of the reform and how this reform gathers, I will go even backwards and try to think about this pendulum that you're saying that we have. And it's not only Mexico, it's I think in the region as a whole, and we were talking before the panel started that the region itself, it kind of shifts towards state control and allowing investment from private parties. And particularly in the case of Mexico, I think that if you remember before the expropriation of 1938, there was private participation. And pretty much the historical perspective, I'm not trying to go with Pablo's topic here, because I know that you're a historian and you probably are the best person to explain it, but you know, the consequences of the Bucareli treaties and the way that there was a lot of kind of like things that had to be compensated to private companies in the U.S. because of the Mexican Revolution, started to gather this momentum for Lázaro Cárdenas to actually conduct this expropriation and the conformation of the National Oil Company and of CFE, the utility company, to start creating these monopolies that actually became eventually national symbols for the Mexican people. And that's what probably was used again back in 2018 with President López Obrador as a way to promote a counter-revolution to the 2013's energy reform that was considered wrongly, but it was considered privatization of national resources. So I think that's what I add up to Juan's comment there.
Yeah, and to follow up on that, you know, in our discussion, in our sort of pre-panel discussion, Luis, you had discussed the theme of energy sovereignty. And that's a sort of backbone of this symposium, but the ability, the right to govern, to make decisions, to have the ability then to have control over a future. And with respect to this panel, we're thinking about energy futures. So in terms of the sovereignty component then, which has been a sort of central explanation for the administration in taking these reforms, how would you look at sort of historical definitions of sovereignty in Mexico, and then how does this concept inform some of that history?
Yeah, that is an actually a tricky narrative that the administration, the previous one, started to use. And I think it has a backbone in terms of, if you think about it, it was really the first time that started to be used because, again, with the expropriation of 1938, the only thing, and then the eventual changes in secondary legislation that were made up of the 60s, the idea that was very fundamental was the fact that everything that was under the subsoil of the Mexican land belonged to the nation. And that's the key component of the idea that natural resources have to be in the benefit of society. And again, the other thing that I would say that kind of fits that into the people's collective idea was that geological luck, that geological strike that we have in finding one of the three largest super fields of oil and gas in the world up today, which was Cantarell. And that where it was, I don't have to go into detail, but it was very poorly managed. And that was used, the revenue from that large field was used as a pretty much a fiscal short-run stabilizer of macroeconomic components in Mexico for years and years. And when it was used that way, then people started to think of Pemex not just as a national oil company, but rather as another figure within the state that was a key component to regional development in the country. Because Pemex was in charge of developing pretty much cities itself, hospitals, education, the whole landscape of cities that were non-existent before Pemex changed because of Pemex. And at one point in the 80s, Pemex was one of the top 5 national companies in the world. And that idea was fixed in the mind of Mexican people. So by the time that geological strike of luck ended, then the energy reform of 2013 was when started to say to the Mexican people, well, you know what, this is going to end. We need private investment to make this work for the future. And because of something that I will discuss later in the panel, that was a key component of the administration of President Peña Nieto, but was closely related to corruption. And it was pretty much politically used by the administration of López Obrador to start saying, hey, let's revert back this liberalization of a market that wasn't even in the interest of the people. And let's use it back to govern our natural resources in the benefit of Mexicans. And that's when he started to fix this idea of energy sovereignty, of we need to conduct the energy sector for us and through us and with self-sufficiency.
And that's a great, I think that's a great theme too for our sort of final sort of session on the sort of globalization, those themes that run through this conversation in particular, because at that time too, we were looking at the era of shale development. And for NOCs, the national oil companies around the world, you look at these models, Petronas, PDVSA at that time, but all of these storied national oil companies were really the experts within their area. And you see the emergence of these large international service companies who can now take the place of essentially consultants. And you can bring in investment, you can start to develop, bring in a partner to help fund it. So it's an interesting time at 2013 as we kind of close on our past. So our next part of the session then looks at the legislative, regulatory, and judicial changes. And so we had an excellent first panel that really put this into perspective. But those 2024 amendments and then the legislation in 2025 has now marked a turn in the national priorities within the energy sector. And we've seen that, and this panel will focus on hydrocarbons, so petroleum, electricity, and mining, lithium mining to a certain extent. And so those reforms now can shape the checks and balances and also the administrative autonomy and ability to oversee these sectors. So to Luis, maybe could you walk us through some of the most impactful changes in the reform and the legislation with a focus on our hydrocarbon electricity priorities?
Yeah, at the constitutional level, they were presented in February 2022, and they were finally enacted in last October. And there are 3 constitutional amendments that are relevant. Changes to Article 25, 27, and 28. With respect to 25, they have to do with the way that the federal administration envisions both PEMEX and CFE, whereas they change of being state productive enterprises as the 2013 energy reform envisioned them, and they become again state public enterprises. And what does that mean? It basically means that if you remember the 2013 reform, they have to be profitable. They had to bring actually dividends to the state. And now with this vision, they no longer have that objective. And changes to the Article 27 have to do with 2 things particularly. One of them is the fact that, and it also gives you a hint about the way and the level of commitment that the federal administration has with respect to energy transition, because it basically eliminates the responsibility of the state with respect to it. So it sends that responsibility to the general law level, and that is something that is also relevant here, because you also had that in the previous reform. And the other change in Article 27 that was with the 2013 reform was the fact that the state could celebrate contracts with private parties to conduct projects of infrastructure with transmission and distribution projects in electricity. That's no longer there. It's considered its sole responsibility for the state. Changes in the Article 28 have to do with the fact that it basically describes all the activities that are not considered monopolies for the strategic industries, and that's specifically where both PEMEX and CFE have to be prevalent. But then again, it also states something that's very ambitious, and has to do with the fact that for planning of the electricity sector, it's regarded as a national security element and has to be conducted with self-sufficiency and promoting energy sovereignty. But at the same time, it also states that it will have to provide electricity for the Mexican people at the lowest, at the most affordable price, which is even at the constitutional level. And that has a lot to do with Article 25, where it states that these enterprises, particularly CFE, do not have that profitable objective, but rather a social objective. And then you have at the general level some goals. And before that, let me just say, when the 2013 reform was enacted, it had changes to those articles, but then it also had 21 transitory articles. And those 21 transitory articles in 2013, they have a clear vision of where the energy sector would go. This was not the case with this reform. This reform only had 1 transitory article that basically said, we eliminate the energy reform of 2013, and that's it. So that created a whole bunch of uncertainty for everyone about what was going to happen afterwards, and a lot of doubts about what we expected from general law. At the end of it, we did have on the 80th anniversary, and 85 anniversary, 86 of the expropriation, the enactment of these 8 new laws, the secondary laws, and the amendment of 3 existing laws, which basically reasserts the state control of the energy sector through 3 mechanisms, and I will end there. One of those mechanisms has to do with the prevalence of the PEMEX and CFE in all the activities that they participate. The second one is unilateral decision-making by the Ministry of Energy with respect to energy transition and sectoral planning. And the third one has to do with with a more strict regulatory enforcement and compliance verification by the state in all the activities regarding the energy sector. So basically, it's back again to the state controlling the sector itself.
Yeah, and for those of us with these long histories in energy in particular, we always know that what's old is new again. And so what is new will be old. I think the theme, though, of volatility with respect to the certainty within legislation, within presidential administrations, and the priorities within those administrations is something we'll think about in our market reaction impact. But before we move to that, Juan, how do you see maybe the reshaping? I mean, I could use the word weakening of regulatory bodies, but a refocus or a reshaping of regulation and judicial independence. How do you see that affecting legal certainty and due process from the investor perspective?
So before I answer that question, I just want to add, I guess, one thing to what Luis mentioned, which is Articles 27 and 28 of the amendments to Articles 27 and 28 also have provisions related to lithium, right? And they make both lithium a strategic resource, it's classified as a strategic resource, and then any activities relating to the extraction of lithium are considered strategic activities. For those of you who are familiar with how that script that plays out, not just in Mexico, but throughout the region, right? It is gives government quite a bit of power in terms of what it can do with respect to that particular resource. So I think it was worth mentioning that as well. In terms of the reshaping, you heard a little bit about that in the previous panel and how the judiciary has been reshaped. You also heard in the opening remarks about the reshaping of the energy framework in Mexico, right? And so I think the perspective from investors, clients, is that it's in many ways a backlash against what was happening. It's a backlash against the rule of law and what was happening during the administration of President Andrés Manuel López Obrador. And let me explain. I think, as we all know, President AMLO ran on a national sovereignty platform. And when he took office, he tried very, very hard to roll back some of the changes that happened in 2013. Now, he did it in a different way, right? He approached it by creating a number of hurdles in the administrative processes. So for those of you who practice in this space, you know, our clients were facing a lot of roadblocks. And so when a client wanted to apply for a permit, or when some sort of authorization, it was really, really difficult to get that. And you get all kinds of excuses. And I can tell you stories of the number of excuses you would come across. And so there was a really challenging time, just from a more practical standpoint. The problem that President AMLO ran into was the courts, right? The courts, by and large, not 100%, and I disagree with some of the decisions, but by and large, they upheld the rule of law. And they were basically saying to President, you can't do that. And so in many ways, that was helpful for foreign investors. But nevertheless, there were thousands of lawsuits that were filed. Again, administrative lawsuits, amparos, constitutional challenges, against a number of the changes that President AMLO was trying to enact, against administrative acts that were being promulgated by the administrative bodies, particularly SENED, CFE, CR, etc. But the courts kind of put a stop to it. And of course, the big decision was, came as late as February of 24, when the Mexican Supreme Court basically said that the changes to the electricity law that were attempted were unconstitutional. And so, again, I think that this is in many ways, it's seen as a backlash to a lot of that. So the changes that you heard about during the first panel to the judiciary and the election of judges is in many ways, it's a response to that. right? And I think what the president hopes is that in large part, the judges that get elected are going to be Morenistas, right? They have 23 out of 32 states that they control. And so with that sort of power, I think that they're hoping that the new changes that are coming about are withheld or upheld by the courts. So I'll stop there.
And in thinking then about the turbidity in this environment and how are investors, how are partners, stakeholders able to make decisions then within this period of time, especially within a transitory period of time where there hasn't been yet a period of adjustment. Our next topic or part really focuses on the market reaction and on the impacts. And as someone with I'm a petroleum engineer, have worked on pipelines, reservoir, oil and gas. A lot of our projects are long-lived projects. So they could be decades, 30, 40, 50. We think about some of these producing basins in the history of the world, the potential for natural gas and electric generation. These are projects which live a very, very long time and don't react well to volatility and instability. So in thinking about that, Luisa, I'll start with you. How have CFE and Pemex reinforced roles that have affected, how have their reinforced roles affected energy markets and thinking particularly about generation, transmission, and hydrocarbons?
Yeah, I think that the reaction to this period, specifically when there was the expectancy about, or the expectation about a major shift in the energy reform. And you have to remember that when President López Obrador arrived to office, and actually when he won the election, the very first things that he said was and promised, and he actually kind of like make a vow, and said, I'm not going to touch anything about the energy sector. And that was a key message of calm and stability, and everything was well. Maybe that's the case. And that was a major narrative that he used throughout his campaign, saying like, I am not going to revert the energy reform. And then, as Juan said, started to kind of like confront directly everything, every piece of the institutional architecture of the reform, up until the moment when he said, well, you know what, I have to change that. And I have to have a new law. So by the time that he started to actually promote new laws, markets were reacting in the very short run to every specific thing that he said. And this has happened up until this energy reform with President Sheinbaum. But at the very same time, there are key elements that at some point the markets have kind of read through the reform itself and believe still that there's certain hope. So for example, there is still a national plan of energy, and despite the fact that we don't have anymore this independent regulator, this independent technical regulator that any efficient energy system will require, there's still a vision that the country needs energy. The country needs projects, infrastructure projects, transmission, distribution, generation. We need exploration. We need to improve our logistics and transports of fuels. We need to explode our biofuels industry. We need to increase our storage capacity. So having said that, and with the lithium component that Juan pinned down before, I think that there's still the expectation that Mexican state and Pemex and CFE cannot do everything. So they will have to act together with private parties to carry out these projects. And the actual National Energy Plan actually foresees that. The key question here is whether there are enough. And if you think about the energy vision of 15 years that we have every year launched before President Obrador, and that stopped with President Peña Nieto, at some point we identified before the energy reform that and in 2012, we required 100 billion US to invest only for the electricity sector in generation, in transmission, and distribution. The energy plan that President Sheinbaum launched, it envisions only 3.5% of that investment. So the country is not even putting the target that we had years ago in terms of the vision for the 2030. And that's what I think has the markets questioning whether if they have that need, can we actually put forward a collaboration or a joint collaboration with the institutional environment that we have now after the reform? And we'll talk about prices in the following question.
And so following that, then Juan, how are potential clients, investors, both domestic and foreign, how are they evaluating those commitments? Are you seeing the formation or counsel being sought in terms of exit strategies, which is always a risk in any type of investment? Or are you seeing just the continuance of trends towards the usual indemnification, private law, contracts, arbitration mechanisms?
I guess I kind of describe this as a little bit of schizophrenia. It really is. I mean, we have, there, I think as Luis mentioned, there is actually a lot of interest by foreign companies, even despite the reforms and the changes. There are, the reality is there's a need, right? And there are already projects that have been announced, 35 projects in the electricity space. The need is there, and I think foreign investors see the opportunity still. And so on the one hand, there is this hope, right, that there's going to be a lot of opportunity. And I think we need to contextualize this a little bit too, right? Because although a lot of people say, you know, President Sheinbaum is a sort of pupil of President AMLO, the reality is she's her own person. And whereas President AMLO put up a bunch of roadblocks with projects, as we were talking about a second ago, what that led to was companies pushing the pause button on investments in both the hydrocarbon sector and the electricity sector. And so there was this sort of reaction to what President AMLO was trying to do, that in a kind of weird way, the reforms that President Sheinbaum has put forth have created this unpausing of the button. And it's like, let's go figure out if we can do this, not just from a legal standpoint, but also from an economic standpoint, right? Does this make sense? Where the schizophrenia comes in is that companies at the same time are looking at this and saying, what's the risk, right? Because companies ultimately are going to be assessing three things: risk, certainty, and confidence. And if the reform, the energy reform, had been it, maybe there would have been more of that. But coupled with the judiciary reform and the centralization, once again, of the energy governing bodies, right? That creates a lot of uncertainty. It creates a lack of confidence, and it elevates risk. And so companies are kind of weighing both of these things. And let me give you a couple of examples. One, from a business standpoint, there's no secret in terms of how well Pemex is doing, right, financially. Well, now if you have to be a partner with Pemex and they're holding 40% of the bag, are they a good business partner, right? So there's risk there. The change that Luis Alberto mentioned from the productive state entity to the public state-owned company is not cosmetic. It's a significant change, because you go from an entire governance that is associated with the productive state entity right? Where there's checks and balances, where there's a need to create profit, to one that puts the public welfare first. And if in the name of the public welfare, decisions are taken that are going to impact a joint venture, right? Some sort of partnership with a private company, that creates a problem. And talked about the centralization. There's another element here that I think is worth mentioning, and it's a little bit hidden, I have found over the years, not just in Mexico, but throughout Latin America. When state-owned entities become much more involved in partnerships with foreign companies, there's this little known provisions that talk about the responsibility of public officials, right? Making public officials personally liable for decisions that are taken or not taken. And so what I have seen over the years, doing this 25 years, is that oftentimes public officials don't want to take a risk. And so they make decisions that are in the best interest of the entity they work for, even if it violates the law. Why? Because if they don't do that and they leave, they're liable personally. And I have seen presidents of Latin American companies be prosecuted for this. So centralizing some of these governing bodies, I think, creates additional exposure for public officials that they're not going to want to go against the platform of the executive. Last but not least, I think in terms of how the market reaction and sort of what companies are looking at right now are really two things. One is kind of a wait and see, because the regulations haven't come out, right? And so the implementing regulations, we'll see, the devil's in the detail, right? So we'll see how they actually, these laws, these secondary laws play out. But I think a lot of companies are looking at the role of arbitration, and more so. Most of the contracts I think that CFP is involved in right now have arbitration provisions. I think those are going to increase. There's no guarantee because the courts are changing, and so ultimately, when you're trying to enforce an award, you're still going to have to go to a Mexican court, and now with a bunch of judges that may not understand arbitration, right? That could be a problem. And again, historical context, right? Arbitration in Mexico is not that old, right? That is something that I think there was a Sur case that finally accepted arbitration as a method of dispute resolution across the board. And it's not that old.
And I think too, that's important what you just said about the knowledge then of the courts to be able to understand the provisions and the mechanics for the provisions, but also in terms of the subject matter of the dispute. If we have a movement away from knowledgeable courts within the within energy contracts, within hydrocarbons, electricity, if there's movements or shifts away from that knowledge, that poses another area of potential concern. But I do think it's important, following on what you just said, to understand that globally there is volatility all around us in terms of political administrations, transitions. Certainly, this is something that we are seeing here, where it is another time of transition and another time of the a sort of a wait and see perspective about how things will shake out, from regulatory, from judicial changes, from administrative changes, and markets, investors waiting and to look to see how things will fall out. But in the meantime, making decisions about whether to pause on investments or to just continue in a sort of conservative business as usual. So moving then from the sort of domestic concern, let's shift the last part of our conversation to international and cross-border implications. and thinking about how energy reform then impacts trade, which has certainly been an area of conversation, but trade, investments, and thinking about the integration and the cross-border nature of energy projects. When we think about basins that cross borders, power lines, power supply, demand areas, all of these are cross-border type of commodities. And so, Luis, I'll start with you and maybe bring us back to sovereignty. Does the emphasis on sovereignty challenge or complement Mexico's international energy cooperation goals? And maybe talk to us a little bit about the status of globalization and how that can maybe promote energy security and transition.
Yeah, it should reinforce it. It should. But the fact is that it does the complete opposite. When you think about the
I didn't want to use the word either. I was trying to end on something like a big positive note, but please tell us.
Yeah, no, it's just that when you think about the 2013 energy reform, it actually happens in a moment of time where we look at the US and what the US and especially Texas did with the shale revolution. And that's something that the Mexican authorities thought at the time, well, listen, that could be us. That could be us in the near future because we share the same geological basin, we have the same resources, we can do that too. So the only thing that happened was that we got probably too late. We got also too weak to establish the probably the mechanisms to enforce the reform. And also, I think that promises were made too large. I think that the 2013 reform said at some point, like, as opposed to what EU Americans and Texans have experienced throughout the shale revolution with low prices of energy, the 2013 reform actually not only said that we would have low prices of energy in Mexico, they said that prices in general for other goods and services were going to be low. And when you react to that situation, looking at the prices that were not that low, that were actually carried out a process of liberalization of including other actors with a whole process of corruption in the middle. And I'm talking about Odebrecht, and I'm talking about Emilio Lozoya Austin, cousin of the president, charging for receiving persons in his personal office at the 50th floor of Petróleos Mexicanos. That's something that was just too much for people to handle in terms of saying we are going to carry out with this reform. So that gives some momentum back to saying we would like to have control of our own resources. But at the same time, Mexico is a country that requires a lot of natural gas. Basically, our economy is based on natural gas, and 85% of that comes from here. So we cannot just be blind about it and think that we will be able, with the type of corporate governance and the economic incentives that Pemex has, they would not be able to take advantage of natural gas fields in Mexico. So that will not happen. So the only way around about this conundrum that Mexican administration has to carry on with projects with the most profitable and most affordable natural gas basin in the world that is located right here. And we need to carry out that. Now, the only way to figure that out, and that's what Juan was pointing out, whether we want it to become an easy relationship or not. And that I don't know. If you think about energy systems that are efficient, let me just say two brief examples. One was the Eurostorm that you experienced in February 2021. And what happened in Europe the past weeks, it's an example of what you might have if you have an energy isolated system, that it's not resilient, that it's not flexible, that cannot adapt to external shocks, whether they come from demand or supply. That's what happens. You get out of energy. There's no more expensive energy than the one that you don't have. That's something that we all guys in the energy sector know. There's nothing more expensive than that. But at the same time, we're seeing mobilization of countries in the world, especially US and the global leaders, towards deglobalization, towards not being politically vulnerable to depending from others. And an energy system that it's integrated is vulnerable by definition to political conditions. So I'm not sure. I have that question back in my mind, probably myself, thinking about if we want low prices, if we want energy transition, if we want the energy sector to provide energy justice, if we want it to become continuous, flexible, reliable, it's simply too much. We might not get there. I'm sorry not being on a positive note, but
You know what? Realism is acceptable. And you know what, Luis, you sound like a lawyer to me. Like, so I think we will. I mean, there was so much to unpack there, because the other question is we have an aging electric infrastructure in all of these areas. And so that also requires investment, which I think will bring us to maybe the sort of conclusory part of our panel, and also flow right into our audience Q&A. And so I'm going to just ask Juan a question about this, and it draws from one of our online attendees. And I want to thank everybody who is joining us online for their participation. But Juan, this question went to legal disputes and the ability of USMCA to step into some sort of role here for a stabilization purpose. So what disputes do you see that might emerge under USMCA or investment treaties with respect to reforms? Or conversely, how might these types of treaties, how might they ameliorate some of the volatility associated? And that pairs along with a question from our audience, online audience member, who asked about what kind of recommendations about to a foreign investor or a U.S. energy company would you make about investing in Mexico?
That's a loaded question.
We're just going full positive on this.
Yeah. I'll start with the last one. I mean, on the recommendation part is, I mean, frankly, it's a little bit of a wait and see. Let's wait for the regulations to come out and see how the devil's in the detail, and see how this all kind of shakes out. There's a lot of opportunity that I don't want that to get lost. I mean, again, the demand is there and the need is there. So there is opportunity, and the reform did not close the country off completely to foreign investment. It actually provides a number of mechanisms for foreign investment to come in and partner with CFE and Pemex, right? So, but how the rules and regulations that are going to apply, that are going to be required to be followed, I think there's a lot to be said there. And by the way, it goes beyond just the rules and regulations in terms of how the schematics are going to work out. There's other changes that are also going to be important for foreign investors to address and deal with. For example, the social assessment changes. That, I can tell you from experience in Latin America, is a big deal. And it's going to create a lot of challenges. So the answer to that last question is like a little bit of wait and see. But I also want to go back, and before I answer your question directly, I want to go back to something that he was talking about, and that is opportunities, right? And maybe not so, this is kind of a challenge, I guess, for all of us. National sovereignty is not something that is unique to Mexico, right? The national sovereignty is something that is being discussed throughout the world, including in our own country. And so that is something that we have to keep in mind. Everybody seems to be honing in on this zero-sum game idea. Somebody wins, somebody loses, right? And so, number one, but number two, I want to throw a statistic out at you. This is something I read a while back. Because of the need for energy that is coming up, primarily as a result of data centers, cryptocurrency, blockchain technology, AI. In the United States alone, there is going to be a need, the equivalent of 44 million new homes by the year 2035. We do not have sufficient generation currently, right, to provide that amount of power. Now, going back to the idea of national sovereignty, right? if we're going to be generating that energy, are we really going to be sharing it with our partners and our friends across the border if we need it in the US, right? Something to keep in mind. USMCA. I mean, I think, again, we're,
Sorry, and one, maybe just, if anyone has a question, if you could raise your hand from the audience. Just the Q&A app, sorry. If you could just put your questions in the Q&A app and we'll get to your questions.
so very quickly in terms of just potential violations of the USMCA and other things, right? Number one, Chapter 22, non-discriminatory treatment by state-owned enterprises. Well, CFE and Amex are given precedence over foreign or third-party investors, private investors. So that alone, right, is questionable. Talk about CFEs, the requirement that CFE be responsible for injecting 54% of energy into the national grid. Again, an example of how CFE is given precedence and priority, and so question how that does not violate Chapter 22. Chapter 22 also has a provision that requires administrative bodies that regulate state-owned enterprises that they must be impartial. Well, we've heard earlier about how CRE and CNH were done away with, and now they're subsumed within the National Energy Commission, right, which is largely as an entity, so it's more centralized. So potential issue there. Chapter 21, we kind of talked about, Alejandro, I think, mentioned a little bit about that. Each country is required under Chapter 21 to maintain a national authority dedicated to anti-monopolistic or promoting competition law. Well, see where that goes with the potential elimination of the Federal Economic Competition. And then Chapter 14, the ratchet clause, right? If a country opens the economy up, you can't roll that back. And I'm not really sure what to say about the recent reform. One more thing, Paris Climate Accord. So the new electricity law, right, emphasizes the commitment to emissions reductions. But they also reinforce, as we all heard, CFE's precedence regarding the generation of electricity. Well, CFE's portfolio of generation is comprised primarily of fossil fuels, 79%. So how are we going to attain the requirements of Paris Climate Accord when we're relying on CFE and CFE is relying on fossil fuels? Not really sure.
I wanted to take another question from the audience. Is there any impact of the 2013 energy reform for the overall state-owned enterprise reform in other sectors? Please, do you want to start?
Well, definitely. I mean, if you think about it, and just trying to, let me just add up something to what I was saying before going into that. The energy transition commitments are also jeopardized by the fact that clean energy certificates are gone with this reform. So basically, that means that you don't have the incentive really to bring this additionality of generation coming from clean energy sources. If you look about eliminating this energy reform and the impact it has with other sectors, of course, the manufacturing sector depends hugely in Mexico from energy, and particularly from natural gas as well. So you do have impacts there. You also have impacts on housing. There was a lot of benefits that were expected to come from flows of investment throughout the years from the 2013 energy reform, coming also to living, to the construction sector. And so there are multiplied effects that still need to be calculated, but that you can actually identify if you consider the value chain structure of the energy sector in Mexico, particularly in the northeastern area. There were a lot of opportunities of investment in there. Now, they can still happen, and there are a lot of people, specifically academia and other business and multilateral bodies, are still thinking, okay, we have this energy perspective, the way President Sheinbaum has. And we have our own separate issues with the idea of national sovereignty as well in the US. But still, how can we benefit from the scenario that we have in front, given that there is opportunity? And what I said there, and what I would say there is that there's still hope for things to actually carry out. Now, hopefully, Chisca and others will let us know what happened after the judiciary reform, because that is something that really, as Juan said before, is going to give us a thermometer of whether we are going to have that hope alive or not. I think, and hopefully we will find a way. Investment always find a way when there's a need. So I think that we're going to have that. But especially coming back to that question, automotive sector, without talking about tariffs, because that's something that they will talk in the next panel. Automotive sector is one of the sectors that's electric, domestic products. They are the ones that have been more impacted by these effects that were canceled from the 2013 reform.
And sorry, and maybe just we have about 2 minutes left, so I think we've covered a lot of the questions already in our discussion. I again thank the audience so much for the questions. Maybe in our last couple of minutes, with 1 minute each for each of you, what's one key takeaway for practitioners, for policymakers who are watching Mexico's energy future? And Juan, why don't we start with you?
It's not all doom and gloom. I mean, I think that's the reality. I mean, we've talked a lot about the challenges that we're facing as a result of these reforms. But I think the other point that we're also making is that there's a lot of opportunity. And it's a question about how to navigate that opportunity in a way that mitigates risk, but takes advantage of the opportunities. And so not all doom and gloom.
I like that a lot. Luis?
Yeah, I would jump into that comment and say that I will revert it. Before I said that only 3.5% more or less of what we require from energy that was envisioned 10 years ago. It's really in the plan for 2030 for President Sheinbaum. I'm going to say the other way around. You still have the opportunity to bring in 3.5 billion US just in the electricity sector in Mexico. So a part of that would be investment with foreign participation, so that mainly US participation. So that's a good note. And on the other hand, you still have those untapped natural resources, non-conventional resources waiting in the Gulf of America here. I mean this side of the country. I want to still go back to my country, so I will say Gulf of America. But you know that Gulf. And then you also have non-conventional land resources from natural gas in Mexico that I think that we can find a way to explore and use. So I think that also there's a very ambitious plan for electromobility from President Sheinbaum that also requires a whole bunch of infrastructure that I think that it would require a lot of investment too. So I think that there's a way we can find out to move around this trouble seas.
And I think that is a wonderful note to end on a note of promise, potential, and partnership. So thank you all so much. I want to please join me in thanking our tremendous panelists. And again, just on behalf of Devon School of Law and the Rowling Center, thank you so much. Again, we're so pleased to be part of this program. So to Eric Hinton, I see Martin Camp and Dean Steve Yeager who are here. Thank you for the law school and Rowling Center support.
Yes, thank you, Monica, and for Luis and Juan. As Monica just mentioned, we're very grateful for this opportunity, and they did a great job of interconnecting this panel with the previous panel and showing how all this is related. And in light of the Texas-Mexico mission of really creating and providing action-oriented recommendations for the Texas-Mexico relations. So thank you very much for that. Next, we will move on to lunch. We will have a room change. We'll be moving next door. Our lunch will be from 12 to 1:25. We invite you to come. You will be sitting according to the numbers that you received, and we'll help you find your seats if you need it. But thank you for joining us, and we look forward to seeing you at lunch, and we'll be hearing some keynote speakers as well. Thank you.
Thank you so much. No, I'm gonna take her home. Thank you. Thank you so much for all of your work. Just such a beautiful job. All right.
How you doing? Nice to meet you. I'm on the floor.
Morena and the machinery of Morena, the different people can put you in the ballot. I think they have a lot of fun. Of course, and another problem is with the gangs. The Mexican gangs are very, very powerful. This is another problem. This is the problem with the criminality. But the political relation between the people, the will of the people, whatever that means, and the justices, I think, is a major problem. And in this very moment, when Morena said that they command the full transformation of the Mexican history, like a dialectic that can develop the national sentiment, this kind of fictions, I think the position of the justice and the judges in general is very, very dangerous from the rationality of the rule of law.
I appreciate you both bringing up the rule of law and really what's going on in this moment. And I thought we would put it in global context. And I took this quote, which I thought was very pertinent, from a Duke Law School publication called Judicature. And this is what they said: from threats to physical violence, attacks on judges and courts are surging. With corrosive partisan rhetoric and misinformation, they're spreading throughout democracy and media, social media like wildfire. While criticism of judicial decisions is a core aspect of democracy, dismissing judges and the courts as corrupt or illegitimate can degrade the rule of law. At a time of declining public trust in the courts, the growth of violence and unfair attacks against judges is raising alarm bells across the profession. And I think we've seen a global reach of this. So I wanted to step back and get your views on the global situation as we see pushback against judges and the judiciary, and even violence toward members of the court.
Well, I will start with a very general review. Of course, in the world, general, many countries in the world live now in this general category of populism. No, it's populism of left, populism of right, populism related to religion. Many possibilities of many components of this general category. But in general, I think that the populism is this idea when a strong leader who understand the will of the people, the concerns of the people, the historical moment, in one hand, and in another one, that this leader have the capacity to transform these concerns in goals, in certain goals, or have the possibility to put the whole people in a very historical moment or in a destiny of the people. And this kind of thing is very, of idea is very complicated, because in that moment, the rule of law don't have a good positions. Because if I can supplant your will, or not your will, the rules with my will, what is the function of the rules? And second one, if the judges are the members of the society by professional reasons or historical reasons, cultural reasons, that try to understand the rules and try to avoid conflicts or resolve conflicts in a certain society, the judges dismiss this possibility, they reduce the function that they will perform in a certain society. I think this is a general problem, not only in Mexico, not only in Latin America. I think it's a general problem from this historical. In sometimes many of you know that the actual time was or compared with the times from the Weimar Republic, the period between war. Okay, it's possible. Of course, we have a strong difference. No, now we don't live with the socialist, Soviet socialism or Nazi or fascist. It's different. But the idea, the general idea in the term, I would say that we have a charismatic leader is very dangerous from the rule of law, because is the will of the leader against the rules that was constructed by democracy. I think it's a huge problem it's not a Mexican problem. The Mexican particularity is the election. This is the cherry, the Mexican cherry, because it's the election. Okay, I understand that in some countries of the Europe, East Europe, they have the same concern. I understand this, but anyone was or choose the election system to nominate them or to dominate the others. This is the Mexican particular, and it's very good. And the other problem is that Chisca said this morning that in Mexico we will establish an discipline court. That for me, this is one of the most dangerous problems. Is a Nazi, a fascist tribunal court, because they have the power to remove every member of the judicial branch except the justice, so the Supreme Court remove, but they can punish it. But with a general nomination like the judicial discipline acts against the judicial discipline or acts against the judicial principles. This is very huge, the possibility to sanction, to punish some judges in Mexico. It's a tribunal with 5 members elected in a popular election, designated what the popular election by vote. This, I think, is one of the most important problems. And the decision of that court don't have a judicial remedy, that Chisca said. And of course, we have a problem with the system of international human rights, especially with the Inter-American system. But in the meantime, we have a lot of problems with it.
Your point about the Weimar Republic was an interesting one. I don't want to follow that rabbit hole too much, but do you think that some of the success of the judiciary is based on the maturity of a democracy and the sophistication of the rule of law in a given country?
Yeah, let me add some things here, like about how democracy and the rule of law can work together, because there is a tension there.
Yeah, and the maturity of both of those.
And the maturity of, but that's a historical tension. But let me try to land this in a more concrete way to understand what has changed recently. I remember that in the 1990s, in the early 2000s, there was a discussion, for instance, in Mexico. You may remember this from many of your cases, about the risks or the peril of litigating controversies in the media, in TV, the newspapers, etc. That could put a lot of pressure on justices. That's in a society in which the level of civics education was really low. That's why most people cannot distinguish between a district judge, a justice of the peace, the fiscalías, the ignorance about the law and the constitutional system was very big. Then we have the digital revolution. We have social media. And that has completely changed the conversation, also with the emergence of this charismatic leadership. Because now, it will be, you can say, as a leader, I have 30 million followers in X, and they are all supporting my judgment on a certain issue, and it's better for the judges to follow my lead. Think about what Justice Cosio mentioned, and Chisca, of the disciplinary tribunal. The disciplinary tribunal can remove a judge because a ruling is contrary to the public interest. How do you define the public interest? It's a very complicated philosophical, practical way. But for governments, it's very easy. You construct public interest. You say, in this particular issue, we must move in a certain way. I have like a whole environment in the media supporting that idea, replicating itself, through digital means. And one single district judge, what is that judge going to do? I owe my appointment to the people. I was elected by the people, and I can be removed if I vote against public interest. So in the end, the role of the judge will be very democratic, but the judge will be constrained by this enormous social pressure that was not even materially possible in 2006 or 2003 when you started working as a justice. I remember, for instance, one very famous case, the case of Florence Cassés, which was one of the first cases that in which the session of the court was transmitted through TV. Well, that was really nothing compared to what is going on right now. So this problem of the illnesses of our democracies will manifest harshly in the everyday life of judges and the rule of law.
Well, in my time, I never feel, I never have concerns. I never feel dangerous against me or people like Chitzka and other people who work together in the Supreme Court. But now the justice field are very uncomfortable. This is, I think, this is a very important distinction. When I was justice, I live in close to the Universidad Nacional de Mexico in Coyoacán. And there are close to there many food stores, many restaurants, and I can walk, buy my books, whatever. But now I think that the judges feel very, very uncomfortable because the people demand that they don't be part of the moment, and they are in a very unhappy situation. In my time, well, the president said that all of us are people, stupid people, whatever. But okay, maybe they have reason, but maybe that don't have. But now, it's true. It's your opinion, but my opinion is the life continue. But now is a very, very different situation.
Some of the commentary, especially in the first panel, focused on some of the other implications. So for instance, we talked about this lunch with the pure volume of candidates that you would see, and also the sophistication and preparedness of those people to actually serve in the judiciary. I'd be interested in your thoughts about those challenges when it comes to how people actually choose someone to vote for and whether those people are prepared to serve as judges.
Well, Mexico don't have a civil service like Europe. No, what is a common track to people who will work in the judicial power? You start very early age. In Mexico, it's very common that the people start working in the first semesters of the first years of the studies. And for example, you are right, district court when you have 19 years old. Is good or bad, but this is another discussion. You start in this moment and you will ascend from different positions. In a certain moment, you take an exams and you will was designated to be judge. And you continue in this position for many years. And in certain moment, you present another exam to be a member of the circuit court. That's true. Be a justice is another question. It's different, have a lot of political implication. I appreciate that any one of you ask me what are these political questions. But No, it's no, but the people have a lot of experience. They remain in the position for many, 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 many years. No, it's a track. Is common. If you don't make huge mistakes, some mistake is common, but huge mistake you can finish at certain age and you leave the position. Well, anyway, and in those years, you learn and rationality, you learn a certain manner, judicial philosophy, this one. What happened now is people without experience, very young, you don't have an age, a minimum age, you have only this kind of things, and she's got said certain a law degree, and you have in Mexico, those 1,500 is 2,500. Okay, School of Law is very important, this position, to 2,500, School of, no, 2,500, School of Law. The possibility that you have a law degree is easy, cheap, is very easy. Well, you don't need an experience. You have at least a letter of the people who know you. It's in general. And I think the true question in law is the rationality. No, I remember this expression that Lord Cook is very famous English judge that said, well, Your Majesty have a natural reason, but the law is an artificial reason. No, it's artificial learning, and it's true. It's good or it's bad. It is another discussion, but it's a very specific rationality that we have. The term, the expressions, well, all of us, no. And the new judges don't have any, I suppose, idea. This is the good part. The other part is what happened with when they have a specific ideology or a specific compromise with the political system or with the narcotraffics. Because we don't talk now about the narcotraffic, but this is a huge problem. The president of our Senate, a very special guy, interesting guy, said the other day that he identified 26 people who are related with the gangs. I don't know if the number is 26 or 100, I don't know, but I suppose that the gangs try to put some people, very specific people, in that position because it's part of the business. They have politicians, they have judges, they have police. What don't I think is part of a huge structure of criminality. This is another concern, different from politics, different from ideology, but this is an important question.
Interesting. And I think we must add one more layer here, which has to do on the way how judges were educated and trained in Mexico, because most people in the judiciary, the Mexican judiciary, learn their trade by working with judges or magistrates or justices of the Supreme Court for some years. It was like a very traditional artisanal system, which you learn the trade by looking at the judge. And there was a lot of work. Someone working as a clerk in a district with a district judge, could be days and days and days non-stop working. The same at the Supreme Court, but there was an incentive beyond, the salary. The big incentive was that you were going to pursue a judicial career. At some point, you will become judge, then magistrate, or if you had the right political savviness, eventually become Supreme Court justice. But that means that not judges, magistrates, even if they're not all of them were perfect or great,
but they knew what they were doing. They understood the trade. They understood the profession, the kind of cases that they were dealing with. They knew the language. They understood the politically, how to navigate the borders, because politically it was very complicated. Now, there's no incentive for anyone to work in the Mexican judiciary. Because if you are going to be cleared for a member of Supreme Court or a district judge, why do you want to do that? You cannot become judge. You will have to go through the political system if you want to become judge. So it's much easier to say, I will start my own career in TikTok. I'm not joking. It's real. As we speak, it's real. Just take some time looking for the TikToks of judicial candidates in Mexico. So that will create that will bring something that it's a huge problem for the Mexican judiciary, that will have a direct impact for the people who use the justice system, that they will deal with a very unprofessional judiciary. And why is this a problem? Because most cases that are decided in courts are not as simple as one could imagine, from a law manual. Law manuals are designed for beginners, for students. The actual cases are extremely, extremely complicated. Just take hundreds of pages. We're talking about financial, economic, criminal, labor realities that require a lot of effort and experience on the part of the judge or the lawyer. Now you will have people who made their career through TikTok or through bargaining with some political leaders in the part of the narcos, or in the criminal justice system, the drug gangs. So that will have an impact in the legitimacy of the justice system, the quality of rulings, and in what I think is very important for this audience, legal certainty.
It's a great point. I want to step back just for a moment to the way that we got here. And you talked about populism and the rise of populism in Mexico, but were there some legitimate reasons or some challenges within the Mexican judicial and legal system that we could take into account separate from the things that are problematic?
Well, I think that my general perspective is, of course, is the same that Chisca or Alejandro did. Mexico, the judicial system in Mexico have a lot of problems. No, it's huge. Many people can't participate in general sense in the decision. But we have a very good diagnostics from CIDE, from UNAM, from ITAM, from the huge institutions, many NGOs that know what we need to do in many cases. But the judicial reform, Chisca said this morning, the judicial reform don't take this specific question. For example, we start in 2008 with the judicial reform in the criminal system. Okay, but the judges change. We learn the new abilities. We take courses. But the police, the prosecutor, the forensic services don't change. You have the same services that in this time. For example, if you ask what can do or what not to do a police in 2007 and what they can do now is the same. They don't have an special training. They don't have more resources. And this reform don't take this problem. This is a big question. The second one is that many people don't see this problem. This judicial reform change only the people who are in command in the different cases. Justices, magistrates, judges in the federal and local level. Okay. But at the same time, you have another huge change that few people understand. In this very moment, we are changing our procedures in criminal law because we don't you finish there. In commercial law, in labor law, in civil law, and in family law. At the same time, this is a huge problem. You change the organization, the people who are working, and the procedures at the same time. I, of course, am not an expert in organizations, but I understand if at the same time you change the people and the procedures, the possibility to fall in big problems. For example, the last year, a new national code in civil and familiar procedures start. But in this very moment, any state, anyone, and the federal, of course, don't start the changes in the procedures. Is a change to an old Spanish and French system to write cases to oral cases. My concern in this point is I nominate the new judges for general category. With these procedures of electoral procedures. At the same time, we need in Mexico to change the whole procedures in, for example, civil court. It's very complicated, and the people from Morena don't make the correlation between the change in the organization and the change in the procedures. I think it's very it's hard. And another problem, the president need to denigrate the judicial function because they need to do a political reform. Well, in the next years, who can have a confidence in the judicial branch? If you say all the time, not only the judges, the procedures are long, the law is a formality. Well, what the people in a very violent country like Mexico in this very moment, the people have a confidence, a minimum confidence in general law and in judicial branch particularly. It's complicated.
I wanted to dig just briefly a little further in something that you said and you implied, and that is legal certainty. So you have structural changes, you have procedural changes, you have really a different application of civil codes. What does that really ultimately mean when you look forward for legal certainty in cases?
It's very difficult because for that reason, you have in this moment the Mexican system is complicated. Many of you know that the juicio de amparo is very complicated. Sometimes I need to explain to people who came from China the juicio de amparo. I understand that was the Chinese torture because it was very, very complicated. To try to explain the amparo to the Chinese people. But this is the problem. It's very complicated. But in general, the cases, the judicial cases in Mexico will go to the Supreme Court in certain forms, or the Supreme Court define the points of law, no, between contradiction in the circuits, like here in the United States, where this is the problem. Well, now you have the Supreme Court here and two chambers. When the two chambers disappear, the Supreme Court, the 9 justices, absolutely don't have the possibility to resolve many cases. It's impossible. No, there are two different systems when you are acting, you are playing in the whole chamber, and when you in the chambers. It's very complicated. I think this is a huge problem. The other is a design because some contradiction between the criteria from different courts will be resolved in regions. Regions is complicated in Mexico. You have different civil codes. Suppose a region that have 2 or 3 states. It's not the same to decide if the code, for example, from Durango, said this one or this one related with divorce or marriage or whatever, that to resolve or define the criteria for 3 different states that have different civil code, only for example. And this is the kind of appreciation that these people, this political party don't have. I think that they only don't, they try to use the law very instrumentalistic way. But again, they don't understand the function, the functions, the possibilities, the effects of the law.
It's a lot of nuance to take into account.
Yeah, and also, I think, when we think about the recent judicial reform, it's hard to know what was in the mind, President López Obrador when he pushed this plan, pushed forward this plan. But it was clearly a reaction to some decisions of the Supreme Court, that he considered particularly damaging, especially related to energy, what Juan was mentioning this morning, and also things related to the military, to the National Guard. So he wanted to make a reform so that the political branches could influence or secure the decisions from the court, which was not the first time in Mexican history that such a thing happened. But the problem was that they decided to extend that logic to all areas, to politicize the entire structure of the Mexican judiciary, from the justice of the peace at the local level, the guys who deal with drunken people in the streets, to the Supreme Court. And the problem is that this system is designed according to a political vision, a vision in which the judge is mostly a political actor that will have to balance competing interests and find like a solution according to the public good, whatever. There are some cases that you can manage politically, but there are thousands, or not to say millions, because we are talking about a judicial system that handles millions of cases every year, that are not manageable through political mechanisms. So what will happen in practice? Well, probably if you're a big company and you are dealing with a very important case in the state court of Jalisco, well, you will do some political lobbying. You will talk to the people who can actually influence the judges. But most people who are involved in judicial cases don't have those kind of connections. So my biggest fear with this reform is that in many cases it will lead to 3 possible things. First, low quality, very poor decisions, just manufactured in mass. Then lots of petty corruption in the courts. Well, you want to get this, well, you need to bribe someone in the disciplinary side, or in the political arena, or in someone working in the court. And something particularly dangerous for a country like Mexico, extrajudicial solutions. And it's hard to see that from Texas, because we live in a very, sometimes feels like a machine, everything works at a certain hour, the lights and the rules, etc. Mexico is way more organic. And the problem with that is that you don't often notice, how many social conflicts are solved outside the courts, outside the legal system, sometimes through political mechanisms, but very often through violence. One of the key reasons why organized crime has grown so much over the last 2 decades is that organized crime took advantage of the weakness of the Mexican state for solving conflicts. I remember the year 2006, 2007, when I was doing research in the state of Michoacán. Actually, the narcos, sometimes were local judges, like solving disputes between families and businesses and whatever. Now, with a more politicized, dysfunctional, weak, unprofessional judiciary, what will happen? Well, this will grow, also because organized crime is much bigger, much more power, has way more money, more sophisticated than it was 20 years ago. So in terms of legal certainty, yeah, it's a big problem because we're going back to a system of political management of social conflict in the end, which is what President López Obrador wanted. He came from a political tradition in which the president was the guy who balanced things, who found solutions outside the law. That doesn't matter. The law is something superficial. But that in practice will have big consequences.
I think Pablo haven't explained this position, but I think this government don't understand what happened when the judges was nominated, designated, elected by these electoral procedures. We have experience only, and it's an strange spirit, but it's the Bolivian spirit. The people in Bolivia understand that, or suppose that the judges will be part of the Evo Morales movement, from the mass movement. They suppose, well, if we choose these people and put in the election, they have a lot of legitimacy and they are our judges. Okay? Now, the people from the mass and the different political parties in Bolivia say, no, when the candidate run for a position in this electoral system, they acquire a proper legitimacy and they act against or with absolute independence from the political party. This is another serious problem, not only in terms of threshold to the government, no. It's a problem of governability because the judges don't understand that the function is to apply the law who was created by the Congress. The judges understand and they have another logic and another difference with the law. I think this is a general problem for the governance of the whole Mexican political and democratic system. It's another problem. And I think that the government, Presidente López Obrador, Presidenta Sheinbaum, don't understand this function. What happened when the judge have his own legitimacy because he or she win in an election? Okay, the people vote for me. I have a constituency. I have my own relation with my constituency, and my constituency say that or that or whatever. This is another problem. No, it's the problem with the guns, with the problem with the political party. It's the problem in the very bad sense with the autonomy of those people. I think this is another problem that I would say.
Well, we're nearing the end of our time. I just wanted to give you the opportunity to make any concluding observations or things that you would like to have as a takeaway for our audience.
Well, I prefer say thank you for the lunch.
It was very good.
Thank you for the invitation. I am member now from the Tecnológico de Monterrey, and thank you for all of you. And I think that this, seriously, this very moment is really complicated, and I don't feel or don't appreciate that here in the United States, not only in the university, but in the United States in general, understand what happened. I think that many of the American elites in the universities, in NGOs, in the government, whatever, are looking for the violence in a strict way with fights, guns, arms, this of drugs, but don't appreciate the gravity of this context, these structures that I changed. If Mexico lost the judges, the United States are in a process.
I agree. Well, thank you so much, Justice Musillo. Thank you, Pablo. Thank you to all of you. We look forward to continuing this discussion next year. So thank you very much. So I think we transition to our next group. Oh, sorry.
No, you can take over if you like, Eric, but yes, I think we could, if you could join me in one more round of applause, thank you. Very enlightening, thank you, Pablo, and the Honorable Jose Ramon Castillo. Thank you very much, Eric, for facilitating this. So we are going to move on to our final panel. I'm going to announce it. It's very relevant for our time. Navigating Turbulent Waters, the upcoming review of the USMCA. We're excited to see you all in our next group. Thank you.
Yes. Well, we get our extra. Yeah, that's what we have to do. Back. We can improve.
La que apareció como un fantasma y pegó el chale.
Online. Oh, different.
They're always like these two.
Yo soy malo. No, what then? Well, I already have my selfie though.
No, you want me to take it? Yo te la tomo. Take it. La voy a tomar ella. Yo te la tomo.
What, all of
Te
this?
doy ya.
Yeah.
Te doy ya.
Okay. Ponte la foto para.
Astrid.
Vente, Marisa.
Hey.
Looking forward to it. That's seriously, I'm out of here.
No, gracias.
Estoy muy bien.
So I hope it will be it's fun. So are you enough business?
Banking, infrastructure, energy, that kind of.
Okay. In the panel from the
Yeah.
Symposium.
Yes.
And we completed the second panel that was about energy. All was from
Check, probando.
You have your card.
Yes. I
Yes. I'll be interested.
Entonces, pero para que no se vea. A las 12 ya. Exacto. Oye,
Yo la testé la primera vez y luego quedaron para que buena se cambió de hecho y yo
voy a salir a
Sí, sí, perdón.
Hello, we're just waiting for people to trickle in and waiting for a final panelist, and then we'll begin, but just a few more minutes.
Creo que a veces nos animan un poco, porque ya la gente está. Pero León, 14. León, 14.
Okay, we're going to begin. So if everyone could take a seat, that would be great. Okay. All right, we are excited to welcome you for our third and final panel, a very pertinent subject on the navigating turbulent waters for the upcoming USMCA. I believe I see a few new faces. And so if you have questions that you would like to have answered during our Q&A session, please use the handouts that you received that give you instructions on how to turn in your questions. So for this panel, we have joining us Francisco Peña, Pedro Alfonso Elizalde, and as our moderator, Ileana Rodriguez Santibáñez. And I will be giving a brief introduction for each. And again, I invite you to read their in-depth biographies in the program here. So Francisco Peña has been a partner at CCN since 2009 and is co-director of the Labor and Employment Practice and works with Cachao, Cavazos, and Newton. And we have Pedro Alfonso Elizalde from the Tecnológico de Monterrey. And he is the Associate Director of the Department of Law at the Guadalajara campus specifically. And Ms. Ileana, sorry, pulling it up. Ms. Ileana Rodriguez Santibáñez is a well-known professor of international law at the Tecnológico de Monterrey. So if we could give a warm round of applause for them, welcome them as our panelists. And before they begin, our final welcome for our name sponsor, Mission Foods, and David Salazar for representing Mission Foods as the vice chairman for the Mission Foods Texas Mexico Center. If we could give one more round of applause. Thank you very much for making this possible. All right, without further ado, the time is yours.
Okay, first of all, congratulations, USA citizen. Right now we have Papa. Right now we have Leon 14, so congratulations for that. Leo, but someone tell us that it's Leon. Leon 14, I don't know why. We thought that is Leo 14. Leon in Spanish. Yeah, but in Latin, Leon 14. Yeah. So here we go. First of all, thank you very much. It is a privilege to be here this afternoon at SMU in Dallas. I want to begin by expressing my heartfelt gratitude to the Mission Foods Texas Mexico Center at Southern Methodist University, SMU, for hosting this important event, to Tecnológico de Monterrey for their collaboration, and to our distinguished panelists, Francisco Peña and Pedro Alonso Elizalde, for sharing their expertise with us today. I also want to thank all of you, our audience, for joining us, whether you are here in person or participating online. Your engagement is what makes these conversations meaningful and impactful. I would like to share a personal anecdote about me. The doctor says that I should drink water every day at the first time of the day, but instead of that, I'm a coffee person. So the other day I went to a famous coffee shop and I was in line thinking, what kind of coffee should I order in a famous coffee shop? So I was thinking it would be the Colombian bean, and maybe a blend of Ethiopian coffee or a South African coffee. And then I thought, what about the tariffs? Maybe my coffee is gonna be very expensive because of the bean. And then in the same line, I was thinking about the milk, and I thought, oh my God, I need to use milk. So would it be oat milk, coconut milk, almond milk? I don't know. What if the milk comes from Canada, that it has already high tariffs? Or, oh my God, finally, I drank a bottle of water. And when I paid the bottle of water, I realized that it was a bottle coming from Swiss that already has 30% of highest tariffs than ever. So finally, the point, my friends, is that how a simple decision like that is to order a coffee, becomes in a complex economic decision, because at the end of all, the high tariffs will impact everyone in here and in everywhere. So I would like to start this panel. Let's make the most of this opportunity to exchange ideas, challenge assumptions, and deepen our understanding of the issues that will shape the next chapter of North American integration. As we look ahead to the 2026 USMCA, the landscape is complex. Labor reforms, shifting trade alliances, and evolving dispute mechanisms are all in play. Today, we'll unpack these issues, focusing not only on legal frameworks, but also on the practical implications for business and cross-border collaboration. So we have divided this participation in 5 parts. The first part is Mexico's position in North American supply chains in navigating turbulence wars, the upcoming review of our USMCA. So Francisco, let's start with you. With global trade tensions rising, how is Mexico working to strengthen its role within North American supply chains? Are there specific strategies or policies you see as most significant? How does this strategy position Mexico vis-a-vis both the US and China, especially as supply chains become more regionalized?
Well, first of all, thank you for having me here, for inviting me to be here. Thank you, Marisa. One of the things that I consider of the utmost importance will be, we didn't know about supply chains before COVID. We became aware of supply chain during COVID and after COVID. That's when it hit us. That's when we realized that, oh my gosh, we're vulnerable. Oh my God, how do I get my hair dryer? Not that I need one though. How do I get my milk or my coffee? How do I get stuff to my house? It was a given. So now that we came across this particular incident called COVID, that lasted what, 2 years, 2.5 years, give or take. We began to explore other options. One of those options, it became when Mr. Biden said, I want my microchips here. because of national security. And the CHIP Act provided a lot of funding to companies that will come to the US and invest in the US in the processing at that time of the microchips. Well, that was just the tip of the iceberg, because after that, since he didn't win the re-election, somebody else did, the whole market changed. And now we are worried about the supply chain at a greater level. What is Mexico doing for that matter? Well, first of all, Mexico is not acting as fast as it could, is mostly reacting as fast as it can. One of the things that Mexico is doing, and I think, to me, this is Francisco Peña, the most important project that we have right now in the making is the train that crosses from the Pacific to the Gulf of Mexico. That, to me, could be the jewel of the century for Mexico. Because it's not going to be a competition for the Panama Canal. There's no way. Let me put it this way. The Panama Canal, you cross over 14,000 containers in 24 hours. This train will only going to be able to cross 2,500 per day. So there's no competition there. It's an aid to the Panama Canal. On top of that, there's another projects that on the side of the railroad, they're going to be factories, and they're going to be producing goods, finished goods, kind of like what the Japanese do. They put the raw materials in their ship, and they begin crossing the Pacific. By the time they get to North America, the product is already finished. And they build the whole product in the sea, no taxes paid, because it's in international waters. So by the time it comes to North America, comes to the port of Los Angeles, it disembarks not a raw material, a finished good. So kind of like that, they intend to put some raw material in Pacific or the Gulf of Mexico, unload the raw material, comes the next train, pick up the finished good. That's, in theory, a very good project. If that is feasible, that is going to help the supply chain for many products, not only for Mexico, but for our region. Now, there's a key part here. Globalization 2.0. Globalization 2.0 is regionalization. That's the new globalization. There are 4 big regions in the whole world: Europe, Asia, North America, and I'm missing one. South of Mexico is the 4th region. That region is going to begin to grow. We are looking into signing right now. The United States has an agreement with Salvador and Argentina. And those 2 countries are being benefited because of this agreement signed with the United States. Are we scared of China as a region, or are we scared of China as a country? There's 2 different stories right there. China as a country is a very powerful country. I mean, come on, let's think about it. History, let's go back. China had over 30 years to prepare to where it is right now. And how did China prepare for that? Very simple. Europe, the whole Europe, United States, Canada, and Mexico sent to China technology and funding. And for 30 years, China received all that technology. There's a difference between when you send technology to Mexico or Canada or Europe versus you sending technology to China. What happens? It's kind of like what happened in Vegas, it stays in Vegas. Well, what you send to China, it stays in China, technology and all. You do not own your machinery and equipment. It becomes ownership of the state of China. So for 30 years, we fed that country. Past administration, we begin to see that the United States begin to impose certain restrictions, and then the region began to expand. China in Malaysia, China in Vietnam, China in Laos. Well, it's coming from Laos, from Vietnam, from all those countries that are not China. But the products, and the raw material, and the funding is coming from China. So it's non-Chinese China type of products. So all of those things comes into play. And that's what we see now with the tariffs. Supply chains got affected because of all the tariffs? No, supply chain got affected because of what we didn't do our job before COVID. Like I said, when COVID hit, we just realized that, oh my God, we're unclothed. We don't have anything to wear. So that's what supply chains is about. So I think what Mexico is doing right now, because it was, like I said, it's reacting. It's not acting, it's reacting. With that, Mexico is trying to support small businesses at its scale, trying to provide new investments, funds to new investments. This train, it could help us, this project, could help us with the supply chain. And most of all, if we don't get hold of the violence in Mexico, you can invest millions and millions and millions. We need to get hold of that, and we're doing it. We're doing it, just to give you an example, 29 of the bad guys that were in jail came over here with a due process. They just said that over here. Could you please take care of this, man, for us? Thank you very much. Kind of like that. They're patrolling the states, the highways, which is good. I live across from Tamaulipas, very dangerous state. Not so much right now at this point. I just learned, and I don't want to say it was confided to me this information, that there has been more shootings in Stockholm in this past 3 months than it has been in Reynosa. 4 in Stockholm, 3 in Reynosa. Let me put it that way. So things are moving along, yes. Because we wanted it to act upon them? No, because we were forced to act upon them. So I think that will help the supply chain as long as soon as we have security, it will help us on the supply chain.
Thank you so much. And I think that is not just South America that is going to be part of the key, but also the global South that is going to change everything in the supply chain. So thank you for sharing that insight, Francisco. Pedro, building on Francisco's points, how do you see Mexico balancing its commercial relationships with both China and the United States? It is possible to maintain economic sovereignty while navigating these pressures? Even if we are not Stockholm, even we have Reynosa.
Thank you. Good afternoon, everyone. Thank you for having me. Pamela, thank you for the invitation. So I think that US is worried that Chinese companies are trying to use Mexico as a platform to access the American market through USMCA benefits. They are concerned about backdoor exports that avoid US tariffs. Because of this, the US wants stricter rules of origin and stronger investment controls to limit China's influence in Mexico. Mexico, in response to US concerns, has stopped encouraging Chinese investment and is trying to align with Trump's trade and security priorities. Important Chinese projects like the BYD car factory has been delayed or canceled. Mexico has also increased tariffs on Chinese textiles and footwear imports, and recently imposed new regulation affecting platforms like Temu, a chain to better control Asia origin imports. These actions show that Mexico is making efforts to comply with US expectations and to maintain a good relationship with its main trade partner.
Well, Pedro, I appreciate your input on this, and let's move to the next part of the presentation. Second, trade and investment measures related to China. And the question is for you also, Pedro. The US is taking tougher stance on trade and investment with China in the context of the USMCA review. Could Mexico be pressured to align more closely with US restrictions? What would that mean for Mexico's economy strategy and global partnership?
Okay. I would say that the new Plan Mexico announced by President Claudia Sheinbaum focuses on expanding local manufacturing of key inputs and reducing dependence on imports from Asia. This includes promoting national industry and attractive investment into sectors like semiconductors, clean energy, and the textile industry. In the 2026 review, the US will likely push through more coordinated policies to limit Chinese role in North America. This will be a sensitive issue for Mexico. We must defend our ability to attract foreign investment, but also show our partners that we are committed to protecting the regional market. Another point is that Mexico's ability to develop its own supply chains and increase domestic production will not only reduce tension with the US, but also strengthen Mexico's position in future negotiations. By focusing on U.S Mexico strategies, we can show leadership in creating a more resilient and competitive North American economy.
Okay, thank you. That gives us a lot to think about. So Francisco, from a legal and practical perspective, what challenges might Mexican businesses face if such alignment is required? Are there ways to mitigate these risks?
Well, first of all, let's live by these three principles: history, rule of law, and compliance. History. If we do not learn about our history, we're destined to repeat the same mistakes that we did in the past. So what are the mistakes that we have here in this USMCA versus NAFTA? Let's go back in history. Very simple. 1994, NAFTA comes in. They gave us 4 years for Mexico to create a strong supplier, vendors, and suppliers chain. We failed. I have a friend. And I said, you bring in these little things like this for the maquiladora industry. How come you don't produce them in Mexico? Well, it's the labor hand, it's the timing, it's the permitting, and all of that. To me, I go get the client, I ask for the quality and the timing that they're gonna start in the process of your project, and then I go to China and I tell Chinese, this is what I need. I need 1 million of these pieces of this quality. They have 7 types of qualities. Number 1, very cheap. Number 7, kind of being the best. So depending on the automotive industry, let's say you have a model that is going to be in the market for the next 3 years. So the quality that you're looking for, this is an explanation of somebody that's bringing stuff from China that right now is about to get broke, I guess. And he's bringing quality number 4, quality number 5, because the product that is going to be out in the market is going to be lasting 3 years. So the quality is about 4 or 5, 3 years. And like that, many products. So instead of us investing in Mexico to become ourselves providers, suppliers, vendors of this international industry, we decided to go out and about to get those particular suppliers and vendors, and we became brokers. So that's history. That's NAFTA. Comes the USMCA, and we're still doing the same thing. So that is gonna force now with these new tariffs and everything like that, and with the support of, let's assume that, with the Mexican government, we're supposed to have now a strong, or we at least believe that we're gonna begin to become a more stronger or strong type of vendor supplier chain of supply to the local industry. So that's history. Now, the rule of law. Well, we just had a magnificent panel about the rule of law. If there's a country that there is no rule of law, there's no security, there's no incentive for foreigners to invest in Mexico. I want to put a parenthetical here with respect to the last panel. I think we're going to be forced out of this reform one way or another. This judicial reform they're going to force us out of it. How? Do not know how, but I cannot believe that our partners, trading partners, will rely on what we know is a failed product. Now, compliance. This is for companies. Compliance. If you don't comply with the rule of law, you're destined to failure. And compliance is not just what we call it in Mexico, cumplimiento, to comply with. No. Compliance as a concept means a way of life. That means I have to do it right, even though nobody's looking at me. I have to do it correctly, because if I don't, somebody's going to get hurt. Somebody's going to get damaged. I'm going to pollute the environment more. So compliance is key on this new this new ruling and the negotiations of the USMCA. What do I see for USMCA negotiations like around the corner? History tells us that when the president wins and end up winning as well the Congress, the next intermediate elections, most likely that president is going to lose control of the Congress. So the politics in the United States are very fast. They only have 4 years, and they have to move quickly. Contrary that we have in Mexico, we have 6 years. The first year is to make political payments. Second, third, fourth, and fifth year, fourth and a half, I would say, is to govern the country. And last year, or half a year and a half, is to pass the way to the next president. Well, here you have 100 days. Franklin Roosevelt, back in the 1931, when he was president, he established that rule of 100 days because the country was in so much depression. So he began to issue laws and laws and laws. Well, right now they're issuing executive orders and executive orders and executive orders. Those 100 days have become like a type of a ruling here in the United States, culturally speaking. You have 100 days to prove that what you said in campaign, you're going to provide with, that you're complying with it. And then after the 100th day, you will start ruling the country. But you only have 3 more years, 3.5 years. This time here goes fast, unless you get but you can get reelected. Oh, but this president cannot get reelected because this is the reelection that he is in. So he has 4 years, and 3 years and whatever is left. So that is what I'm seeing. So in my mind, that negotiations for the USMCA is going to begin this year, because next year we're on election, and if he loses the control of Congress, what is going to happen? They're going to hold him back, and we don't want that. So, well, he doesn't want. So what I'm thinking is he's going to push to start negotiations to finish those negotiations before next year's elections, on the intermediate elections. That's my thinking.
Thank you. I mean, it's amazing the way you present this information about the perspective about 3 principles, that is history, rules of law, and compliance. That's a very helpful perspective. Thank you so much. So let's move to part 3, labor reforms and rapid response labor mechanism. The rapid response labor mechanism has been a key feature of the USMCA with an increasing number of cases. So, as I know that you are an expert in this, Pedro, how is Mexico preparing for a possible expansion or tightening of the rapid response labor mechanism in 2026? What kind of adjustments might we expect or push for from the Mexican side?
Okay, let me explain this mechanism. The rapid response labor mechanisms, or RLM, allows the USA, Canada, or Mexico to directly address labor violation at specific facilities. It is fast and designed to protect workers' rights, especially the right to free association and to negotiate collective agreements. How does it work? A complaint can be initiated by a government agency, a labor organization, or even an individual, as long as they provide credible evidence of a denial of labor rights at a specific facility. Once a complaint is filed, the country that receives it must investigate. If the violation is confirmed, the country can activate the RLM and formally raise the complaint to the Mexican government. If Mexican rejects the petition, a panel can be established to verify compliance. If Mexico accepts the petition, the parties agree on a remediation plan within 10 days. If no solution is found, a panel of labor experts will verify the situation at this facility. If the panel confirms that labor rights were denied, the complying country can suspend tariff benefits or even block products from that factory from entering. I think that in 2026 review, the US and labor groups will likely push for even stronger enforcement and faster procedures under the RLM. Another point is that in 2026, we'll be expanding the RLM's scope. Some groups are proposing that this mechanism should cover more industry beyond manufacturing, such as agriculture or services.
Okay, thank you, Pedro. You know what? I recently wrote an article about this mechanism, and I'm not sure if it's working. I mean, we already lost with Grupo Mexico. It's a powerful actor in Mexico's economy, and they won the case. And the labor force was like, what is going on with this mechanism? I don't know, but maybe, Francisco, you have mentioned the importance of trilateral cooperation on labor issues. What mechanism could be developed to address labor concerns without relying solely on the rapid response labor mechanism? Maybe some do want to talk about compliance in this part. Thank you.
Well, let me just get one clarification here with the rapid response labor mechanisms. When there's two chapters in the USMCA, one is from the United States to Mexico, and the other one is from Canada to Mexico. Mexico has no rights to claim back. So it's only them to us. That's it, because we're the bad guys. We're not in compliance. Remember what I said, compliance? Well, when 2019 labor reform was issued in Mexico, it was forced on us the way it was. When the USMCA was renegotiated, it changed from NAFTA to USMCA, it was approved, but Pelosi back then told Mr. Trump, his first administration says, I'm not signing anything unless you add the following, which is the RRLM. They put it in, and it passed. And now we have them. Now, when Biden won, those mechanisms were, in my mind, they were abused. They were used like when you get a headache and get a Tylenol, or when you get a headache and go to see the doctor. What is it you do? Well, I get a Tylenol because it's faster. That's how they were treating the rapid response labor mechanisms, as if they were Tylenols. Somebody complained, my head hurts. A mechanism. oh, somebody didn't like the way it looks, mechanism. So we have over 30 plus level response mechanisms right now in place. Well, the first one that was televised and you can watch it in a YouTube video. Mexico was so prepared for it that it beat the US team. It was kind of like the Olympics or the World Cup. It was two teams, legal teams negotiating, and a panel of 3 individuals. And each of those teams were presenting evidence. And one of the key evidence is that the violation to the law occurred prior to the USMCA coming into effect. So constitutionally speaking, you cannot be judged something with this new law, something that occurred in the past. That was one. And the other one is the United States was trying to assert that Convention 87 and 98 were violated. Mexico responded that the United States cannot issue that because the United States has not ratified that conventions from the International Labor Organization. So it's a signature to it, but it hasn't ratified that. Mexico is a signatory to the International Labor Organization and has ratified those agreements. So therefore, by constitution of the LOI, they cannot enforce those mechanisms because they're not part of it. So, and the result is that the panel decided that that particular case had to be dismissed, not on the merits, but on the form, which is the violation occurred prior to the USMCA coming into effect. So nothing to the structure of the violation was treated or was even spoken of, because the resolution was prior and got dismissed because of that. Now, what can we do as an individuals to minimize those kind of rapid response labor mechanisms? Compliance. I've been telling my clients that what they need to do, because everybody's afraid that if they get that, they're gonna get, well, what is the consequences? First of all, we need to see what are the consequences. Well, first of all, you're gonna get fined. It's money, I pay the fine. What else? Well, my IMEX license, which is a way of doing business in Mexico without paying taxes when you import temporary raw materials, can be revoked. That's something that we don't want. What else can happen? Well, you're going to be forbidden to manufacture things in this country with your plant and export it to the United States. You can export it to Europe if you want to, but you cannot export it to the US. Guess who is the largest consumer market in the world? United States. So why would I want to send it to China or Asia or Europe? I want to send it to the United States because it's the largest consumer market that I have. Well, those are the biggest consequences. Like I said, fine, money is money. You just pay it. But losing your IMEX or losing the possibility to be able to export it from Mexico to the United States, that's a big no-no. So people get scared of that. So right now, there's a lot of new unions that they want to go and knock your door and, hey, I want to in and you have to give me the right to talk to my people and all of that. I tell my clients, look, have them talk outside, not in the plant. Because if you let them into your plant, you're violating your collective bargaining agreement. Because you have an existing collective bargaining agreement. It only belongs to this union, not to these guys. I'm not telling that your guys cannot belong to another union if they want to. They can belong to whatever union. But if they want to talk union matters, outside my plant. Because this plant belongs to this other union. So those are the things that we need to be aware of. Compliance. If you don't comply and follow the rule of law, then you could be in jeopardy with respect to these matters. And the other unions know. Just to give you a very quick example, the first problem that we had it in Matamoros with a company that violated bluntly the 98 and 87 agreements from the LOI. And that violation forced them to rehire all the employees that they have terminated, get a voting on the new collective bargaining agreement, which the existing union didn't win, and the new one won the collective bargaining agreement. So it's important that if they would have followed the rule of the law and be in compliance, they would have not been in the first place in that position. So it's very important that people understand at the corporate level and then cascade it down all the way to the plant that they need to comply with the rule of law. Without that, it's no man's land.
Okay, thank you. Let's move to part 4, dispute settlement mechanism. But following up on your point of view, we have seen several high-profile disputes under the USMCA. What are the main challenges with the current dispute settlements mechanism? Are there particular reforms to expect to be tabled in 2026?
There are many labor reforms in Mexico in place. Some of them already voted in, like we can call it the chair, the law chair. And that's kind of like, what? Yeah, exactly. That's the same thing we say in Mexico. That happened because, and this is a story behind that law. And it's not a law per se. It's commonly known as a law chair, but it only modified 4 articles of the law and 3 transitory articles. That's it, 4 articles in the federal labor law. And how it started is that this senator, a female, went to this store, like dealers or those, Target or some of those stores, and she wanted makeup. And there was this lady late in the afternoon, and she was very tired. And the senator told her, have a seat. And she said, I cannot sit. And she was like, why not? Well, they forbid us to sit because we have to be ready for the customer that comes in, for the client that comes in. And if we're sitting down, we give the impression that we don't care, that we're not ready for them. And she was very, very tired. So she got mad, this senator, and began to work and came up with this reform, this labor reform. And now it's in effect. Now, it was thought, that law or those changes were thought just for commerce and services. But guess what? The unions in the industry lifted their hand and said, hey, what about us? We wanted that law for our industry as well. So now they opened the channel and they also included the industry. So right now, that law is in effect beginning June the 20th. For the companies to be in full compliance, it's going to be by around December the 20th. So by December the 20th, they're supposed to have chairs, they're supposed to have spaces so they can rest. And the secondary regulation must be out by July the 20th, this coming month, in 2 months. So all of that is coming in for the 2025, 2026. What else is coming that is kind of like tricky? Well, we're in the midst of talking about reducing the work shift. The work shift is not only, there's 2 ways to do it. To reform the labor law or to reform the Mexican Constitution. If you want to reform the Mexican Constitution, before it was going to take an act of God. Now it's going to be very simple to do it. And if they want to reform just the law, it's going to be a simple majority and that will be it. So it depends how they want to do it, that will do it. Now, this was kind of like the end of an era from the past president that, oh, we're going to change from 48 to 40. We're going to do it right away. We're going to do it. And he didn't do it. We have open parliaments. We have open forums. We have tables of discussions. And nothing happened. Comes this new president in May the 1st. She said, we're going to do it. But we're going to do it in phases. Okay. Phases.
And we're gonna do it all the way to 2030. And then you start thinking, look the political time, the timing. 2027, we have political elections, midterms for us. 2030, we have political elections in Mexico, president, the whole thing. So how do you think that we're gonna tell, oh yes, in 2027, we're gonna move from 48 to 45. And then by 2030, we're gonna move from 45 all the way to 40. That's taking advantage of a political situation to amend or change the law in favor of a group of people to be benefited from the elections. Those are the main aspects of laws that are coming in Mexico that are hitting the wall, let me put it that way, and being expected. So I think that the companies need to understand that. They need to prepare themselves, they need to train their people to minimize the risks. If training has become right now, and every time I give a conference, I tell them, this is what you're doing, you're training yourselves. Training has become the key part of surviving in Mexico. Things are not the same. And if you do not understand that, then you're in shallow waters and you're not gonna be able to row the canoe out of it.
Wow, that gives us a lot to think about. So we are on time. So before that, I don't know. Let's look to the future. Could each of you, or maybe Pedro first, share one key recommendation for businesses preparing for the 2026 review of the USMCA? What should companies keep in mind as they plan for possible changes? Pedro, to you.
Yes, first of all, I want to explain the currency context. International law is in crisis. The WTO is weak. Its appellate body is not working. The USMCA is under political pressure. President Trump has ignored international law using national laws. Because of this, Mexican companies must prepare for risk and uncertainty. Yes, other markets are smaller and farther away, but we need options. Businesses should push the government to support the trade diversification. Lawyers can help companies in 3 key areas: ensuring compliance with rule of origin, improving international contracts to reflect currency risk, and supporting labor right compliance in Mexican factories. Thank you.
Thank you for sharing that point. Pedro, do you have any answer?
Well, let me ask this. There's been talking about in the media, newspapers, and all that. We need to diversify. And I say no. No. Okay. Let me put it this way. Which one of all the countries in the world is your #1 ally? And when I say ally, is your biggest market, the US. Let's not misunderstand sovereignty. Let's not misunderstand nationality. Those terms needs to be adjusted of what we knew back in the 70s. For some of us, we understand what 70 means. For all of the ones, they need to read the history. But this is what is happening. If you want to diversify, make sure that you diversify with countries that are aligned with the United States. If you're going to diversify with a country that is not aligned with your USMCA region, you're asking yourself for trouble. Now, the USMCA do not, and let me repeat that, do not prohibit signing free trade agreements with China. With China like that. It doesn't say China. The USMCA doesn't say China, but it does say non-market country. What is a non-market country? A non-market country is a country that subsidizes entrepreneurs. It's a country that manages the coin, the currency, at its will. It goes up and down whenever he wants to. It's a country that does not have a free trade, a free market between themselves. Whatever the country says goes, that's what it is, and that's what it goes. So China clearly is a type of market or a type of non-market country. So therefore, USMCA Article 32.10 specifically says that if you want to sign an agreement with a non-market country, you have to give us 3 months notice. And in those 3 months notice, we, Canada and United States, are going to decide whether we want to continue with the USMCA or not. And we have 6 months to cancel that. So it is important that if we want to diversify in Mexico, we choose a country market or an ally to the USMCA region. Otherwise, vamos a bailar con la más fea. We're going to dance with the ugly one.
And when you were talking about China in this part, in Mexico, we call the poison pill. If we get very close China, it's going to be a great problem for us. So thank you all for your insights. Now let's open the floor for questions and comments. Whether you're a business leader, a lawyer, or a student, we welcome your perspectives and queries, especially on how these issues might impact your work or sector. So we already have one question. If one of you want to answer, please. And this is Mauricio Roland, and he is writing to us saying or asking, if do you think that Canada will be a major competitor is like keyword, to Mexican interest in the USMCA? Who wants to answer that?
I mean, it's not a competitor. I mean, it's a partner.
It's a complementary one.
Yeah, to me, Canada is not a competitor. We could share few things here and there, but at the end of the day, let me put it this way. Canada may have low-cost type labor, but not as low as Mexico has. So we cannot compete there. So it's not a competitor. Canada has a lot of investments in mines in Mexico. So it's not a competitor, it's a partner. So I don't see Canada as a competitor. Again, it could be in milk, could be in meat, in some cases. United States sell to Mexico a lot of meat. So I don't see, basically, again, I don't want to be repetitive, but I see Canada more as a partner than a competitor. I know that Canada said that they wanted to have signed a bilateral agreement between United States and Canada and leave Canada out. Well, guess what? When NAFTA came in, the agreement was going to be between Mexico and the United States. And Mexico said, let's invite Canada. And that's how it happened. And now this is where we are.
Pedro, do you want to answer that, or would you like to answer the following question? That is, are there any red lines Mexico or the US should avoid crossing in the negotiations?
Yes, I answer the last question. I think that national sovereignty is a top priority to Mexico. President Claudia Sheinbaum cannot allow US interference in national security matters. Such actions could violate principles of non-intervention in domestic affairs. Remember that Claudia Sheinbaum rejects the petition of Trump to give access of American troops to fight cartels. Thank you.
Thank you, Pedro. I would like to ask to Francisco, in the current environment of high tariffs and upcoming USMCA review, what do you see as the most promising opportunities for strategic alliances between Mexican and Texan business leaders? that could create a real bilateral competitive advantages?
Well, let's put it this way. Texas is the #1 trade partner with Mexico, of all the states in the United States. As simple as that. It's the largest continental state that borders Mexico. And not only from the market standpoint, Texas is crucial for Mexico. Texas is crucial for Mexico because we have ties. We have roots that goes 2 centuries back. And to give you an example, we are signing agreements, especially universities are signing agreements, private universities signing agreements to go and study in Mexico or come from Mexico to study in the United States. Here's an example, SMU is one of them. One of the things that I think that Texas could benefit from it and the commerce that we have, you have Laredo. The port of Laredo is the #1 port that crosses many things. And we have the second important border crossing, which is Far Texas. In Far Texas, you introduce through that port of entry 33% plus of all the produce that is consumed in the United States. 33% comes through that port. So, and it goes to east, most of them. Where is the heaviest population in the United States? In the east. So, as you can see, there is no way we can separate ourselves from Texas from Mexico and Mexico from Texas. There is, on top of that, some states have signed, and some cities from Texas have signed sisterhood agreements with many other cities of different states in Mexico. I've been part of several signing of those treaties or agreements, let me put it that way, where the sisterhood of McAllen and Monterrey, Mission and Querétaro, Far Texas and with Zacatecas, I think is the other one. And then there's associations that the economic development corporations sign agreements with CONCE, with AEM, with Canaco, with Coppermex, sign agreements to do business together. Memorandums of understanding between universities is very common. So there's a lot of trading, not only in the sense of articles, but in the sense of, I will say, trafficking minds.
The Mexican law permits these agreements, ciudades hermanas.
Okay, we are moving here. We have a lot of questions. So this is from Hiroki Takeuchi, and maybe you know something about TPP. And he is asking that could you comment on the roles of TPP? Also, what is Mexico's role when TPP and EU members begin collaboration?
Well, okay. Here's the story of TPP. And that is something that it was going to be the agreement of the century. It comes from first administration, and it goes out the window. If you ask me, it was good, but I'll deny it in public. Anyway, I will say 85% of the USMCA, the language, the verbiage used in the USMCA comes from the TPP. The simple as that. So the TPP and the USMCA, they're sisters from a different mother or a different father, but they're sisters. The TPP, Mexico is a signatory to that agreement, and so is almost half of Latin America and Asia. The biggest thing that didn't fly with the United States, the excuse I will say, the violation of human rights. And the violation of human rights was the straw that broke the camel's back. Because little countries in Asia didn't respect labor, child labor. Because then the childs over there are good labor and they produce money. So United States is against that. So the countries didn't want to fix that. So United States says, we're not doing business with you guys. So, and that's just an example of many other women rights and other rights that they were violated. So to me, that was kind of like the excuse to break away from it, which was, I mean, a real one excuse. The TPP right now, to me, is dormant because it doesn't have the infusion, the big infusion that they were hoping for of the market of the United States.
Well, I don't know. I guess China and Russia maybe can have that place in the TPP in other ways. But let's see. The other question is, how do the panelists see the USMCA as tool against authoritarianism in Mexico? And I will say positive. So what about you? The authoritarianism in Mexico, how do you see the USMCA as a tool of pressure against Mexico? I mean, I think it's positive. All the pressure is positive because crisis represents change and opportunity also. But what about you? What do you think?
USMCA definitely is going to be used as a tool to pressure change to Mexico. I mean, you're so integrated with the whole region. I mean, let me put it this way. If we had an agreement signed with Guatemala, with Brazil, with, I don't know, Norway, how much of a business relationship do we have with those countries? Some may say good, and some may say not that good. How much of a business relationship we have with the United States? A lot. How much business relationship we have with Canada? A lot. So if you think that the USMCA cannot be used as a tool to force reforms within Mexico, I can give you an example. Labor reform 2019. Through the USMCA, the labor reform, the way it was because of the USMCA. One of the things that occurred at that time is that they made all the companies to legalize their collective bargaining agreements. And that was specified in the USMCA. So that is a way of how the USMCA could be used as a tool to pressure politics and legislation in Mexico.
I just want to give a fact. Remember that President Claudia Sheinbaum sent 14 Kimpi to USA.
Again,
Details, yeah.
29 bad guys, I call them.
Okay, well, thank you to our panelists for a rich and engaging discussion, and to our audience here online for your participation. The upcoming USMCA review will shape the future of North America trade, and conversations like this help us navigate the turbulent waters ahead. Thank you so much, Jim, for having us here today. And of course, all the team and Tec de Monterrey, Luis Serra, Pamela Romero, and everyone. But of course, thanks to you for coming today. Thank you so much.
Thank you very much.
You all going to get the
Of course, go ahead, please.
Please, thank you.
Stay there.
Thanks.
Yeah. Well, once again, this is on. Is it working? There we go. I think I got it on. Okay, well, this is the hardest of the hardcore. You're all still here. and you're awake. You look like most of you are awake anyway. It's very dangerous to give a microphone to a college professor, especially at the very end of a conference, especially when I'm told I have to do, apologize for my Spanish, el gran synthesis. So I got to do le grand synthèse, as a French would say. So how do you summarize this conference? And I should confess up front, know there's at least one other political scientist in the room here. And we do have a historian sitting up here on the front row. The historians have to keep us honest in what we do. They are, the words of an old Greek colleague of mine, history is the mother of us all. I think that's the way he put it to me. But I always say, since we've got a lot of lawyers in the room, and I hope you won't be offended by this, the world is basically run by lawyers and economists, but they need historians and political scientists to explain to them what they're doing. Okay, that's about as happy a remark as I think I will make in these conclusions. The rest of it's pretty gloomy. But as a political scientist, I mean, one of the big takeaways from all of this, and I hate to use the horrible metaphor of the elephant in the room, but it's convergence. I mean, we have seen populism sweeping many societies in the Western world. The United States, Mexico are part of this. We're not immune to it. From Brexit to Trump, if you want, to AMLO. So I guess you could say the US is becoming more like Mexico, more like Latin America, or maybe vice versa. But one thing is for sure, our societies are changing, very fundamental changes that are happening in our democratic societies. We are seeing a kind of radicalization of politics. I think that's more familiar in Latin America, maybe. But the United States has had its radical moments as well. And I was really struck at the lunchtime panel with Justice Ramon Cosillo. You can see that we're in a phase of more direct democracy, and that's what populism is about, where the will of the people is being translated somehow directly into policy over the heads of the judges and even sometimes the elected representatives. So moving to sort of a liberal to an illiberal democracy. I think Fareed Zakaria wrote a great book about illiberal democracy. We might go back and reread his book. But just a few comments here. I really enjoyed all the panels. The first panel really brought us back to the issue of rule of law, which is often one of the first casualties when you see this kind of radicalization of politics. And politics trumps the law, to use an expression. I remember I spent many years of my life in Europe, especially in France, and the French always frowned on American democracy because they called it le gouvernement des juges. You know, the judges are ruling and running things. They were proud that in France they didn't have judges and justices that were so powerful. We've also seen the weakening of the administrative state. And here I'm at risk of sounding like a political scientist or a sociologist. We all need to go back and reread Max Weber on why it's important to have an autonomous, independent, and non-corrupt administrative state. We need the administration. Ramon, I'm not sure if the Roman codified system is better than the common law system. Again, we could spend the rest of the afternoon debating that. But clearly, we've seen a weakening of the administrative state and its autonomy. Boy, look at what's happening in the United States right now. So we're, at least in a political science sense, we're sort of going backwards here. But again, The idea is that the deep state should not thwart the will of the people. So if you just translate the will of the people directly into policy, again, you have to eliminate the liberal elites and the administrators. The problem with this, of course, is that you cannot have markets, free markets, without the rule of law. I mean, that is key. I think almost all of us in this room, especially the lawyers, would agree on this. And you can't have rule of law without a strong administrative state and an independent judiciary. So again, this is something I think a lesson that history, if you will permit me, teaches us. If you just look at the areas of study of the Texas-Mexico Center, and I would remind you that this is a center that is devoted to the study of public policy, and we very deliberately, working with our founders and donors, decided to focus on 5 issue areas. Let me just remind you what those are. And most of them have been discussed in one way or another in this conference here today. And if you look at these 5 areas, right now I would say the glass is perhaps half empty. So if you look at trade, lots and lots of setbacks with trade, a rise of protectionism, mercantilism, a zero-sum approach to economics, tariffs, and that is a setback. I was reminded as Francisco was discussing USMCA and NAFTA, that article by Paul Krugman back in the 90s when he wrote an article about NAFTA. I think the Mexican economy in 1993-94 was slightly smaller than Ohio. So if somebody had to worry about this agreement, obviously the Mexicans had more to worry about than the Americans, but Krugman said it's foreign policy stupid, which means, you know, Mexico is opening up, Mexico is democratizing. Very important to support this, this kind of new political economy, if you will. The second area of focus for the Texas-Mexico Center is energy. I wonder why we would be focused on energy, sitting here, standing here in the state of Texas. And we had a great panel, thanks to those of you who were on that panel. Unfortunately, again, glass is half empty. We've seen a Back to the Future scenario under AMLO, and now his successor, a renationalization of the energy sector. And of course, we know from our studies of economics and economic history, when the state gets involved taking over and running things, it's not always the most efficient way of organizing your economy, shall we say. But I understand the Mexican concept of patrimonía. So, and again, Mexico is a neighbor to the United States, so as is Canada. And I always like to quote Pierre Elliott Trudeau, living next to the United States is like sleeping with an elephant. Every time it twitches, you get very nervous. So the third area of focus for this center are borders. Again, we have regressed with respect to borders. I always told my students, my children over the years, I hope I'll live to see a normalized border between the United States and Mexico. We're right now going sort of in the other direction, although we'll see how far we can go to closing the border, because that's going to have big economic costs. The fourth area, and this is an area where I have spent my life studying this issue. I started studying it said you cannot write your thesis about immigration. It's a non-issue, a non-topic. Nobody cares about that issue. Well, guess what? It is the issue, I think, of the 21st century. I'm going to be in Japan giving a series of lectures at the beginning of June, and guess what the Japanese want to talk about? Migration. I mean, this incredibly aging society. They got to have migrants. And I've been writing articles about this, some of which have been translated into Japanese. Some of my ideas have found their way into the Japanese diet. But manpower, human capital, I mean, just look at the lunch that we had today and the people who prepared and served the food for us, if you don't think migration is important. But the fifth area for this center is the most important one in many ways, and it's education. Education. Again, Francisco made some good points about this. But that is the future. The need for exchange, fluidity, that students can go comfortably and study abroad without the fear of having their speech repressed or their visas revoked. Yes, migration can lead to a brain drain. That happens. But one thing we've discovered in studying migration, that brain drains can lead to brain gains. And then you can have brains that circulate. So I think one of the objectives for us here in this group at SMU, at Tec de Monterrey, is we want to see more brain circulation with the human capital that will cause both societies to grow, prosper, and flourish. I was going to go through a glass half full scenario, but I'm going to have to leave that to your imagination. So you can go through these 5 and think of what the glass half full. I just want to make a few final comments. Again, I apologize for sounding like a political scientist. That's what I am. Almost all my professional life, I go back to the founding of the American Republic, the founding fathers, very worried about presidential systems of government because they can descend into what I call Caesarism. Spent many years of my life in France. There they call it Bonapartism. So there's always a danger that democracies can become a bit more autocratic, authoritarian, especially if they have these strong, popularly elected leaders, presidents. So these are the dangers of direct democracy. How does the law constrain this? We're supposed to have a limited republic in the United States. That, I think, should be the model. But direct democracy, you have fewer limits. And when you take away those limits and focus so much on the rule of a single individual who claims to represent the popular will, you quickly run into problems of instability, legitimacy, as we discussed, and big problems of accountability. I go back and forth a lot with my closest English friends. I certainly dream about the British Westminster parliamentary system, where they can get rid of a prime minister pretty quickly if they run into problems. So all of this is bad for business in a way. It's bad for investments. I would say, have we reached the end of what I would call the liberal interregnum, the post-war international liberal order? I think the jury is still out on that one. And if we have reached the end of that system, what comes next? I mean, have you heard any great ideas to replace the Bretton Woods system? But I would just conclude by saying I do think one of the things that makes the Texas-Mexico relationship work, David, is business. And business people have a way of being incredibly pragmatic. Historians, I had a history friend who said, "Oh, you political scientists, you're terrible. You lurch from one crisis to another. You have no perspective." So I think business also can provide a steady hand and help us get through what has been described as the troubled waters. And my final comment, habemos papam. And he is a real American. He is Peruvian. He is an American. États-Unien, how do you say that? I can't say it very well in Spanish, but also an American U.S. citizen. But listen to this. He has a French father and an Italian mother. A French father, an Italian mother, Peruvian American. So I wanted to end on a positive note, and I think that's a pretty positive note. So thank you all very much. Thank you for coming.